All right. Ms. Rivers, can you hear us?
Good morning. Yes, I can.
Good morning. Let's get started. We have a final plea calendar for this morning. And for those of you who haven't had a final plea before, this is the last day in which you can enter a plea, if that's your plan in a case, and have the ability to withdraw that plea if the sentence that you get as a result of the plea is in any way more severe than what your lawyer asked for. After today, your case will move to a trial calendar. Most of the defendants on this calendar, this final plea calendar, will be on, I think it's our January 10th trial calendar of early next year. So we'll keep moving your case along. If you don't resolve it today, you should expect to resolve it early in the new year by way of trial. You can always enter a plea after today, but after today, you wouldn't be able to withdraw the plea if the sentence you got was different from the one your lawyer had asked for. So with that, let me find my trusty pens and we'll get started. Position 1 and 2 are both Mr. Fields. We've got Mr. Hiles here. Good morning, sir.
Good morning.
How are you?
I'm well. How are you?
I'm well. How was your Thanksgiving?
It was good.
Anything exciting happen?
No, and I think that's a good thing.
Well, all right then. Is Attorney Sheeta? Yes, Attorney Ben Sheeta is on the call, and then Mr. Fields, I trust, is in custody. Okay.
Yeah, sure.
There he is. Let me get you. Whoops. Get you on the spotlight right there. Great. Good morning, sir. How are you?
Great morning, Judge. How you doing?
I'm okay. Did you have a good Thanksgiving?
Yes, sir. It wasn't long enough, but it was great. I can't complain.
Well, there are other holidays coming that may be longer in just a few weeks. So Mr. Fields is here. He's in custody. We can bring him out in a moment. He is on the consolidated criminal trial calendar that Judge Emerson and Judge Newkirk will be handling that starts next week. But he does have a final plea day today. He was on a final plea calendar several months ago, but you were busy and asked for a few months. You got 3 and almost 4 months since that last final plea calendar, and I need to know what the plan is now. So why don't you guys just give me a brief description, then we can bring Mr. Fields out and he can hear on the record what we're doing.
Your Honor,
So I spoke with.
I'll
me and Attorney Hiles have been going back and forth, and we had an offer. I relayed that to the client, and he wants a trial, Your Honor. I just need to go sit with him and go through some of the stuff. I've just been on a trial calendar. I'm actually about to walk in for a trial right now. I just forgot to file a conflict with you, so I said, let me log in. I'm also on 3 trial calendars on the 4th, so I'll be filing conflict for that as well. So right now it's a trial posture. I spoke to the state. We're still working to try to resolve it. I know my client has, I think I want to say 8, 9 matters. And the offer would resolve all of his matters. So I just need to sit down with him and go over a couple of things, and maybe he'll change his mind when it comes to that. But I just been in trial, so I haven't had time to go sit with him. But I did relay that message to him. That's where he's at. That's where we're at right now.
Okay, well, why don't we hurry and get him out here in the courtroom so he can get all that on the record. Mr. Hiles, what were you going to add?
What I was going to add is, yes, I made an offer. He's picked up several new cases in the jail. And today, there was one that was particularly grievous at the end of October. And my legal assistant's filing a 418 motion on that right now. I apologize for the late notice, but it didn't happen until the very end of October.
Okay.
And however, I did relay an offer, which would be to plead to counts 19 through 23 on the indictment. The 23, let me see, 23 SC 186465. And then I would null process all the 22 SC case, and then we would decline to go forward on the other charges that happened in the jail if he enters into that.
Okay. Well, we'll get that on the record. Mr. Benchita, tell me, you said you've got some trials set for next week. Are they older than this one? That's why you think you have a conflict, or what?
Yes, Your Honor. All of them are either 18, 19, or 20 matters, and the people are still in custody. So those are in Upson County, Coweta County. I want to say I have something also in Fulton with Judge Cox that I have to follow as well, that his is a newer matter. And there's another county, Your Honor. So, but I'll put that in the conflict.
Okay. Well, any one of those would be sufficient because it's older, and that's for the week of the 4th. What about the week of the 11th?
I have to check. Let me look at my calendar. Judge.
Sure.
Now, the week of the 11th, Judge, as long as nothing from the 4th goes into that, it's just motions, but trial will trump that.
Okay. Well, we will see how that plays out. The 418 motion may get in the way because the judges who staff this consolidated calendar don't work through substantive motions. They try the cases or they take pleas, but I might be able to do that. We'll see. It depends on what's going on in here. Otherwise, it may just roll into the new year. It's a little deceptive. It's a 23 SC indictment, but Mr. Fields has been in jail. It'll be 2 years soon. I guess it just took a while for the gang case to get indicted.
And then I think also with that, Your Honor, from my understanding, is because the cases continue to pile. That could be another reason why he's still in.
Well, he's certainly not going to get out, that's for sure, until he resolves these cases. But he may need to be relocated if where he is now isn't safe for him or for others. Do we think he's back there? Okay. Yeah. He can come to the podium. Can you adjust it a little bit? No, you're good. You're just a little tall. Can you angle it more, Deputy Gordon? We have his buttons. There we go. All right. So let's go on the record with Mr. Fields. He's here in court. He's positions 1 and 2 on our final plea calendar. His lawyer, Mr. Benchita, is on the screen. He is about to go into another courtroom in another courthouse to start another trial. Mr. Hiles is here, the prosecutor. And Mr. Fields, today is your final plea date, which is a date where if you were to enter a plea today and your lawyer were to make a recommendation to me, and I'm making it up, so don't stick with this, but if he were to say, oh, I think Mr. Fields should get 5 years to serve, and I were to sentence you to more than what your lawyer asked for, today you could withdraw your plea. You could say, no, I was good with 5, but you gave me 6. And so no thanks, I'd like to go to trial. After today, you can still enter a plea, but you won't be able to back out of that plea if the sentence I give you is more than what your lawyer asked for. Does that make sense?
Yes, sir.
Okay, so you can still work something out with your lawyer and the prosecutor. It's just whatever you guys work out will be what you recommend to me, and then I'll tell you what I think the right sentence is. But for you to make an informed decision about, well, I want to go forward today or I don't, I need to make sure you understand what the state's offer is. And your lawyer and I and the prosecutor were talking just for a minute before we brought you out here. And Mr. Hiles, the prosecutor, had said that he had it shared with your lawyer, who shared with you, that the state's offer is for you to plead to 4 counts in your, I'm going to call it a gang indictment. And you don't need to say I'm in a gang or not a gang. It's just you have 2 indicted cases right now. There's an older one that says you had some drugs. And there's a newer indictment, it's old conduct, but a newer indictment that says you allegedly did some things in a gang. There's a whole bunch of counts. And the state's offer is that you would plead to counts 19 through 23. Everything else would be dismissed. Sounds like you may have picked up some new cases while in jail. The state would decide not to move forward on those new cases. You would plead to those 4 counts, and that would resolve everything. The state's recommendation for those 4 counts?
The state's recommendation was 20 years to serve 15 years with the balance on probation.
Okay, so big sentence, small number of counts, but it wraps everything up. What the state would be recommending is 20 years to serve 15. Let me make sure I'm looking at those counts. See, 186. 465. And Mr. Benchita explained he's been talking with you and you weren't particularly interested in 15 years to serve, which I respect. But I just need to get all that on the record. And it's good that he's been telling me, but this is an important enough event in your case that it also needs to come from you. Normally, your lawyer does all the talking, but a couple instances I need to hear it from you as well. I'm just pulling up the indictment so we can be talking about the same counts. So 19, 20, they're all okay. They're all alleged violations of the Street Gang Act. And supposedly they involve an aggravated assault that occurred in December of 2021. Was it your understanding that that's what the state would recommend, 15 years to serve, followed by 5 years on probation?
Yes, sir.
Okay. And Mr. Benchita had said you had respectfully declined that. I just want to make sure that's still the case, that as of now, you're not interested in pleading to that. Is that correct?
Yes, sir.
Okay. That's fine. We're going to move your cases to a trial calendar. You're actually on a trial calendar that starts next Monday. It's a 2-week calendar. Your lawyer is a busy guy. He's going to be in trial on an even older case than yours next week. He may be available the week after. And so if we can get him and you in court, maybe we'll be able to try that gang case. We may not. There's a motion that the state has filed that relates to something that allegedly happened at jail last month. I may need to hear that. But either way, now that you're saying no thank you to the state's offer, I can get your case on a trial calendar. So we can get you your day in front of a jury. The jury can hear about what happened and then decide guilty, not guilty. Of course, if you're found guilty at trial, you don't get to back out of any sentence. If you're found guilty at trial and I sentence you, I'm making a number up, but if I were to sentence you to 20 years, you don't get to say, oh, no, thanks, Judge. I don't really want the 20 years. But the entire time you're in court, Mr. Benchita will be here to advocate for you and argue for what he thinks is a reasonable sentence, and I'll certainly listen to him on that. Do you understand all the things we've been talking about?
Yes, sir.
So you understand that after today, the state's offer of 20 to do 15 is gone.
Yes,
they may renew it, but the next time they talk to your lawyer about resolving it, it may be 20 years to serve, and you don't get to say, wait, what about that 15 years? It may get better. They may learn that witnesses are hard to find, and they may, hey, would you take 5 years? Maybe you'll take 5 years. I don't know. But you don't get to try to enforce today's deal again. You understand?
Yes, sir.
Any questions for me about anything we've talked about?
No, sir. Where can I speak to my lawyer?
Well, you can. He's right there, so it would be public. I can't have you speak publicly, but we can hear from him as to when he can come see you next. Mr. Benchita, when do you think you'd most likely be able to see Mr. Fields or connect with Mr. Fields?
By God's grace, Your Honor, it will be this week. If I can't personally go, if I'm in trial, then I'll send my law partner. Someone will see him this week.
Okay. Pardon me?
Can I call? I said, can I call you today?
Oh yeah, say less, most definitely.
Okay. Have you met Mr. Benchita's law partner before? Okay, so you'll know who that person is. Great. So he or his partner will see you. You guys keep talking. And Mr. Benchita, of course, if you and Mr. Hiles sort something out, let Ms. Nelson know. My case manager, we can get the three of you together anytime. We don't need to wait for a trial calendar. That will give Mr. Fields some closure and, more importantly, get him out of Rice Street if there is a meeting of the minds. But if you guys are at the 5-year end of the spectrum and the state is at the 15-year, there's not going to be a meeting of the minds, and we'll make sure we get a trial as soon as we can reasonably do that. Mr. Benchita, last question. I know you need to go, but last question for you. Do you feel like you've got the discovery in this case? That was another reason you had asked for a several-month delay in proceedings.
Yes, Your Honor. I picked up from Fulton County. I dropped off, I believe, a terabyte hard drive, and it has, I believe, all of his matters on there. So, yes, Your Honor.
Okay, good. Mr. Hiles, do you have anything else you want us to discuss while we've got both Mr. Fields and his lawyer here?
No, I think we've covered it. That 418 other action motion should be hitting the I guess clerk's office any this morning.
Somehow I knew it was coming. I guess you told Ms. Nelson. She said something about a 418 on its way.
I did mention it, and I found out about this last one rather late. It happened late in the game.
Okay. Well, I will take a look at that, and then we'll look at Mr. Benchita's schedule or his partners to figure out when we could hear that. Okay. Do you have any questions, Mr. Fields, for me?
No, sir.
Okay. Well, it sounds like you'll get to connect with your lawyer or his partner sometime soon. We'll move your case to the trial calendar. Thank you, Mr. Benchita.
Thank you.
Thank you, Your Honor. I appreciate it.
You bet. Ms. Willingham, position 11 says Ms. Clark on it. Did you mean position 12?
No, it's actually, position 11 is actually mine.
Brashear.
Yes.
Do you not also have Harris?
Judge, I do, however, we've resolved that case.
Oh, I got an email about some things that had been resolved. So let me see if that was one of them.
I'm sorry, I should have made that clear too.
Yes, that was resolved with a plea. Okay.
Your Honor, may I be excused to go to Judge Ingram?
Pardon me?
May I be excused to go to Judge Ingram's courtroom?
I don't know about that location, but yeah, no, that's fine. Did you have anything else here or this was it?
Should be it.
I think that's it.
Yeah, that's all I had, Your Honor. I knew.
Okay.
That. Thank you.
Be on your way. So you, Ms. Willingham, have Mr. Brashear's case.
Yes, Your Honor.
All right, is Mr. Brashear here?
He's fine.
He is here.
Yes.
Oh, he just went to the restroom. But we can do that. All right, so. While we're waiting on Mr. Brashear, Ms. Wood, what's your latest contact with Ms. Tidwell been like?
Not productive, Judge. I submitted a request for a second evaluation on October 31st.
And I didn't do anything with that?
So you've done everything.
Oh.
I issued court services, so there's a second evaluation in process.
Okay,
Yes.
that's where we are with that. Okay, so this may be a case, these may be 3 cases that go to the competency docket.
Correct.
Okay. Do we have an update from?
I do not, I was going to request a recess to an inquiry calendar, but now that you're starting as a competency docket,
Well, no, it can't go there unless and until there's a finding. If there's a finding that Ms. Tidwell has decompensated and is once again not in a position to assist you, then that would be a basis to move her 3 cases to the competency docket, which is where they would promptly go, because then that could be the focus of what's going on and it wouldn't have to be recycling here. So my question was, if you had been able to squeeze an update out of, I don't know if we say Grady or Emery, or I don't know the managers of that process.
I have not gotten an update on what to expect.
Okay.
An answer.
Why don't we reset to an inquiry calendar, I guess, early in the new year, or that's probably the.
That would be my request.
Okay. Ms. Clark, do you have any objection to that for the 3 Tidwell cases?
No, Your Honor.
Some of this predates you, but we've worked with Ms. Tidwell for a while, and I guess at some point she was stabilized, but we've had interactions with her where it doesn't seem like that had necessarily persisted, that level of stability. And so Ms. Wood asked for a reevaluation. I guess we're waiting on that to occur. All right, we'll do that. Ms. Tidwell will be brought over. There was a delay in getting her here. Should we even bring her up so you can chat with her, or would?
I would like to check on her, Judge. So yes, I'll talk to her.
Okay, sorry. All right. If we could have Mr. Brashear come sit with you or at the podium, what's your preference?
He can come sit.
Okay. All right, let's pivot to position 11. That's 23 SC 188396, State versus John Brashear. Mr. Brashear is here. Good morning, sir. With his lawyer, Ms. Feely, and this is Ms. Willingham's case for the state. Ms. Feely, do you have all the discovery you think is out there?
I believe so. I just got some more added that I'm going through now, but yes, I believe so.
Okay. Is what you just received the type of the discovery that means, gosh, we need to hold off for motions or anything like that? Okay. Ms. Willingham, is the state ready to move forward on this case?
Yes, sure.
Okay. Is this a case we're resolving today, Ms. Feely?
I hope so. We're still negotiating, but Ms. Willingham says she can come back. So at worst, this will be non-negotiated, but I believe we could get closer to negotiated.
Okay. So you want to go see Judge Eaton and then come back, or you want to talk more?
Well, if we're gonna talk more, I don't know how many other positions Ms. Feely has, but I'm happy to talk a little now. And if I need to stay, I can.
We can manage Judge Eaton. Ms. Wood has some of the others. We've got Ms. DeBro is on. She's got one. So we've got a couple other things we can do. If the 3 of you want to talk, why don't we do that?
Okay.
Okay, so we'll pause this one. You guys keep talking, and I'll go back to the regular order of presentation. Keandre Logan.
Yes, sir.
There he is. Let me take that off and get you on. Hey, Mr. Logan, how you doing?
Good. How are you?
All right. Do we have an attorney from Mr. Apt's office here, or an update from his office?
Yeah, they said someone to tell you that they was doing a conflict. They was doing a conflict or something like that. Right, in conflict.
Okay.
He's in trial right now.
Do we know, does Mr. Apt have one of the YSL defendants still in the mix? So he is literally in trial now after 9 months of picking a jury. I think they start the trial today. Okay, then we can't move forward with this one. Ms. Clark, have you had any success connecting with Mr. Apt? He's worked with a couple of your colleagues on this one.
We haven't spoken about this case, Your Honor, but I did reach out to make sure that he had received all of the discovery.
Okay, and what did he say?
I'm waiting for a response.
Okay, all right. Mr. Logan, you've been able to speak with Mr. Apt?
No.
How did you know he was going to have a conflict?
My mother, she spoke with him.
Okay. All right. Well, we're going to need to reset this one because of his unavailability. Hopefully, now that the trial has started, we'll get some guidance from the trial judge as to when they're taking breaks in that case, because that's going to be several months. And my hope is that the judge takes a few Fridays off so the lawyers can go do other things, and we'll try to move this case along. All right. Are you on an ankle monitor?
Yes, sir.
Do you pay for it or does the county pay for it?
County.
How long have you been on the ankle monitor?
Since July 3rd.
Of this year?
Yes.
Okay. All right. Ms. Clark, anything else we need to talk about on this one?
No, Your Honor.
Okay. Mr. Logan, thank you for giving me that update. You are free to go. We're going to let Mr. App know. You still live at the same address?
Yes.
Okay. All right. You'll get something in the mail when you need to be back in court.
All right. Thank you. So I can leave?
Yes, sir.
All right. Thank you.
Judge, I do think we potentially can get this resolved today. I need to reach out to a victim, and I have 2 victims waiting on Zoom and Judge Eaton. So I want to call the victim on this case and then at least show my face for the other 2. Those cases should be really quick.
Sure.
And then I will head back up here.
Great. I'll be here. We also have a 1 o'clock and Ms. Feely's on that. So, but I don't want to keep Mr. Brashear waiting longer than he needs to either. Why don't you go do your Eaton thing and we'll pick this up as soon as we can.
Okay.
All right. Next up is Ms. Gibson, who I have seen online. There she is. Let's get her on. Good morning, Ms. Gibson. Can you hear us?
Good morning, yes.
Great. And Ms. Wood, you, if you guys will turn your little camera back on. Did you press a button to stop it or it just magically stopped?
I did not.
Okay. Why don't you do that? So Ms. Gibson had Mr. Toller as counsel for a while.
Yes.
That relationship ended. So I know you're new to the case, and I'm going to let you set the pace for the case for a little while as you get up to speed. It is a final plea date. My preference, if you say, gosh, I need a little more time, would not be to set another final plea date, but to preserve Ms. Gibson's final plea rights for the upcoming trial calendar, unless you tell me, look, this is actually one that's sufficiently complicated. We ought to bake in a whole nother final plea date and move it from the January trial calendar.
No, Your Honor, that would be my request as you just laid out. Ms. Gibson is actually very proactive. She's already been to my office and shared some discovery that she wanted me to share with Ms. Clark. I have been uploading that. I don't know if it's completed yet, but Ms. Clark and I are talking about this case. I don't think it'll resolve today, but I do expect a resolution short of trial. So I would ask that it go to a trial calendar with the final plea rights reserved.
Sure. So we'll do that, Ms. Gibson. All that means is at the latest, I will see you on January 10th. That's when we have our trial calendar with your case on it. You'll need to be here in person for that. But I may see you before if you and Ms. Wood work something out with Ms. Clark after Ms. Clark has a chance to review this information that you've been sharing with Ms. Wood that may provide the other side to the story that's always out there. You are preserving your final plea rights. And what that means is that when you do, if you decide to enter a plea, when you do that, you would have the ability to withdraw the plea if the sentence that I gave you was more severe than what Ms. Wood asked for. So if she asked for 3 years probation and I give you 5 years probation, you could say, gosh, no, I'd rather go to trial than have that extra probation. More importantly, you'll have a chance to talk with your lawyer about it. It's not a guessing game. What's the judge going to do? I'll tell you what sentence I'm going to impose. And if it is more severe than what Ms. Wood asked for, then we'll take a break. You guys can talk about it. You can say, well, I'm not thrilled, but I'm going to take it. Or no, thanks. I'd rather go to trial and let a jury decide what's going to happen in the case. But we're not there yet. I'll keep those final plea rights open. Ms. Wood will keep talking with Ms. Clark, and we'll take it from there. Ms. Clark, anything from the state on this case?
Other than the fact that the state has served discovery, and we did receive the reciprocal discovery this morning from the defense, and we have actually made an offer in this case for the defendant for count 1, aggravated assault, 5 years, balance probated. For count 2, possession of firearm by during commission of a felony, 5 years consecutive. And then count 3, 5 years probation, a handwritten letter of apology to the victim. And also, Your Honor, a behavioral incentive date. It will be our recommendation of 4 years. So
okay.
That offer has been made.
Got it. So as I understood that, it's 5 years probation followed by 5 years suspended, or was it 10 years probation?
It's actually 10 years probation.
10 years probation. Okay. But with the behavioral incentive date, if everything goes smoothly, close the case down after 4 years of supervision.
Yes, Your Honor.
Okay. And Ms. Gibson, you don't need to react to that at all. That's just Ms. Clark sharing with me the offer the state has made. You and Ms. Wood will talk about that. Ms. Wood may talk with Ms. Clark about changing that offer, and eventually we'll get everyone together, and you're going to decide, I'm going to enter a plea. It may be non-negotiated, where you argue through your lawyer for a different outcome than what Ms. Clark argues for. Any questions about any of that?
Not at this time.
Not at this time. All right, sounds good. And you've got good contact information for Ms. Wood?
Yes.
All right, Ms. Wood, you've got Ms. Gibson's contact information?
Yes.
All right, Ms. Gibson, then I'll see you at the latest January 10th here in court. Maybe before then, if you all have sorted the case out. You are free to go.
All right. Thank you. Have a good day.
You too.
Thank you, Judge.
Marquise O'Neill. What are we doing with Mr. O'Neill's case?
If we could come back, Judge, and just speak with him and see if we can work something out today.
Sounds like a good idea, looking at the charge. Susan Johnson Cook.
Good morning, Your Honor. Kimberly Burrows DeBro on behalf of Mrs. Cook.
How are you?
I'm good. How are you?
I'm doing well. Where is Mrs. Cook?
Mrs. Cook is present.
Okay, here I am. Thank you.
Ambassador Sujay.
Yeah, let me cut that out. Yes.
No, that's fine. I just want to make sure we're talking about the same person. Hello, Mrs. Cook. I'm Judge McBurney. How are you?
Fine, thank you.
So this is the final plea date in your case. You're a co-defendant in the case with Mr. Cook. Your charges are very different from his charges. And we're having to hold off a little bit on Mr. Cook's case. We'll still handle it this morning, but his lawyer is stuck in court elsewhere and will be joining us, it looks like, in about an hour.
Good morning, Your Honor. Sierra Lawrence, on behalf of Mr. Richardson this morning, he asked me to appear for him and make an announcement on this case.
Oh, great. All right. Well, I add you to the spotlight. We're going to handle Mrs. Cook first, and then I'll hear from you about Mr. Cook.
Thank you, Your Honor.
Sure.
If I may, Your Honor,
yeah.
This is Cook's case. We just received an offer on Friday. We are still in discussion with ADA Clark about that. We believe that we'll be able to resolve it, but as Your Honor can tell by the indictment, Mrs. Cook's case is very intertwined with Mr. Cook's, her son. And so if the court will allow us to just hold for our announcement until we're able to better understand what is happening with her co-defendant's case.
Okay. Well, then let's flip it around. We'll get Mr. Cook on the screen along with Ms. Lawrence. But please stick around, Ms. Cook.
All right, so do I go off camera then?
You can be on camera or off. I'll remove you from the spotlight there. I just need you to stay on the Zoom call because in just a moment, I'll be bringing you back.
Okay, thank you.
All right, there is Mr. Cook and good morning, Ms. Lawrence, and we got Marge Simpson in the background. Ms. Lawrence, can you rejoin us?
Yes, I'm here.
Great. All right. And let's see if. All right. I gotta add one thing. Give me 1 second. Oh, I'm not able to do it. So I need, I guess, Ms. Clark, if you don't mind, coming to the podium so they can see you. I can't get your monitor to connect.
All right.
Or you can actually just sit, if you sit in that third chair there, they can see you on that screen.
Got it.
All right, so let's go on the record with position 10, State versus Samuel Cook. It's 23 SC 188389. Mr. Cook is appearing virtually with Sierra Lawrence. And Ms. Lawrence, you are a partner with Max Richardson, or you are affiliating with him for the purpose of this case, or just so on the record we get it clear, what's your connection to the case?
Yes, just affiliating with him for the purpose of this announcement, Your Honor. I'm an attorney that works in his office.
Okay, great. And so today's the final plea date. It's the last day Mr. Cook can enter a plea if he's interested in doing so, and withdraw that plea if the sentence he gets is more severe than what you might ask for on his behalf. Tell me what Mr. Cook's plan is here.
Your Honor, Mr. Richardson has conveyed to me that he just received an offer this past week during the holiday break, and he was out of town, so he has not had the opportunity to communicate this offer to Mr. Cook, and would be asking for a continuance of this final plea to have that discussion with him.
Okay. Ms. Clark, what was the offer, if you're the one who conveyed it to Mr. Richardson? What was that offer?
Your Honor, the offer from the state is 10 years to serve 5.
Okay. Ms. Lawrence, were you privy to what the offer was, or just that an offer was conveyed?
Just that an offer was conveyed, Your Honor.
Okay. So what I'm going to do is treat this in the same way that I handled Ms. Gibson's case, which means I'm not going to put it on another final plea calendar. I'm going to keep it on that January trial calendar, but I will preserve Mr. Cook's final plea rights. So in effect, when we call the criminal trial calendar in January, Mr. Cook will have another final plea opportunity where he could enter a plea and withdraw that plea if he felt that the sentence that was imposed was more severe than what he had asked for through Mr. Richardson. Does that make sense, Mr. Cook, what I just described?
Yes, sure.
All right. Where are you living, Mr. Cook?
Grant Park.
All right. And you've been on bond for a bunch of years now. This is an old incident. You don't have to wear an ankle monitor, do you?
No, sir.
Okay. All right. Ms. Lawrence, anything else you wanted to share during this calendar?
Nothing additional, Your Honor. I just wanted to confirm that trial calendar is January 10th.
I'm pretty sure that's correct. Let me confirm by looking at the instructions I got. Yep, that's correct. January 10th. And Mr. Richardson and Mr. Cook will both get notice of that, but we call the calendar on January 10th, and that will be Mr. Cook's final plea date as well. But if he doesn't resolve the case that day, then it's not that we go to some other calendar. He's already on that trial calendar. Okay?
Thank you, Your Honor.
You bet. Mr. Cook, any questions about any of that?
No, sir. Thank you for your time.
All right. Thank you, Ms. Lawrence, for filling in.
You're welcome.
All right, let's get Mrs. Cook back on and Ms. Burrows to Bro. So you heard what Mr. Cook had to say through council. What are we doing with Mrs. Cook?
Your Honor, we would ask for the same treatment. We believe that a resolution in Mrs. Cook case will swiftly follow after the resolution of Mr. Cook's case if he's able to resolve his case. And so we would ask that we hold the final plea date open till the January trial calendar date.
Okay, I follow that, and that's not a problem. If Mr. Cook in the end says, I'm going to trial, then does Mrs. Cook's case swiftly resolve because she goes to trial alongside him? Or what happens in that scenario? Because you've always described it as, well, when Mr. Cook pleads, then Mrs. Cook's case is simple. If he doesn't get an offer he likes and says, gosh, I'm going to go to trial, what do you foresee happening?
I still foresee a resolution, Your Honor.
Okay. All right. We'll do that. Ms. Clark, anything you want to add in connection with Mrs. Cook's side of the case?
No, Your Honor.
All right. Mrs. Cook, where do you stay?
In New York?
Are you in New York right now?
No.
No. You're in Georgia right now.
Yeah, for the holidays.
Oh, okay, good. I hope you didn't come down here just for this to say, hey, I want more time. You will unfortunately need to be here on January 10th. And hopefully your lawyer and you have sorted something out. I don't mean to drag you back down here multiple times, but the one caveat to you needing to be here is if you do resolve the case short of trial in advance of your son's trial, and the way it's resolved is something that doesn't involve you going into custody at all, I'm generally okay with a virtual appearance. It gets a little complicated if you're going to be on probation. And I'm not saying you're going to be on anything. Maybe your charges are dismissed. I don't know. That's a decision for the prosecution. But that would require you to come back to Georgia to plug in with probation. You've got a great lawyer. She'll explain all that to you. But you should hear it from me, so you don't have to blame your lawyer. You can blame me. You'll need to be here in court on January 10th, unless your lawyer gets some special dispensation for me to say, well, for this one person, she doesn't need to come to court. All right?
Got it. Thank you.
Excellent. All right. Thank you both. You're free to go.
Thank you, Your Honor. Have a great day.
You too. Well, we're moving lots of cases down the road. Let's see. We've got Ms. Love is the last case we haven't talked about yet. Is she here? Are you Ms. Love? Yes. Hey, how are you? Good. Ms. Wood?
If we could come back to this, Ms. Clark and I are actively emailing about this case.
Okay. Should we take a break then? Because we've got Mr. O'Neill maybe working his case out. People need to talk. We've got Ms. Love maybe working her case out. People need to talk. And Mr. Brashear, but we don't have Ms. Willingham right now. So I'm going to go back there, let one of the deputies know when any one of these cases is ready, either for a plea or it's not a plea. We need to move it to the trial calendar, and we'll get that on the record. Okay? Great. Thank you all. And
I have an announcement on Mr. O'Neill, position 8, and a plea on position 13, Ms. Love.
Okay, and any update? I know it's not your case, so I guess you would know, Ms. Clark. Oh, no, it's Ms. Willingham's. What we're doing with Mr. Brashear.
Ms. Feely is talking to him in the hallway.
Okay. Okay. Well, let's get on the record. Why don't we do Mr. O'Neill? Mr. O'Neill, if you'll come, you can sit right there with Ms. Wood. Ms. Rivers, can you hear us again?
Yes, I can. Excuse me. Yes, I'm ready.
Okay, great. You guys need to go to the podium if that's okay. I can't make the video start there. I was trying to turn the video on.
No worries.
Okay, Mr. O'Neill, you are position 8. It's indictment 23 SC 188293, and you are charged with an offense involving distribution of marijuana. Ms. Wood, do you have the discovery in this case?
I do, Judge.
All right. Ms. Clark, what's the offer that you've made to Mr. O'Neill if he wants to resolve his case today?
Your Honor, 3 years probation with forfeiture of the Glock 45, 9mm that was confiscated at the time of arrest, special conditions, gainful employment, completion of GED, drug and alcohol eval after 30 days, and no known affiliations with gang members or communications thereof, in displaying of replica guns, and that's based off of the defendant in this case is currently on probation.
Okay. Was he on probation when he got arrested for this?
To my understanding, yes, Your Honor, he was. And I did see on the GCIC a probation revocation, but I'm not sure if it applied to this particular. He actually has 2 cases.
Okay. And we don't need to work through all that if, I guess, if we're not sorting it out today. I'm just looking at his docket. Okay. So, Mr. O'Neill, you understand that state's recommendation, if you were to plead today, would be 3 years probation.
You understand that's the state's offer?
Yeah, I'm not asking if you like it, just do you understand that if you said, yeah, I did it, which you don't ever have to do, and your whole approach, maybe I didn't do anything, but if you did say I did it, or I'm pleading guilty, the state would recommend 3 years probation.
Yes, Sean.
Okay, is that's not a sentence you're interested in?
No, sir.
Okay, all right. Then we'll move your case. It's already on the trial calendar. January 10th, you'll be back in here and we'll be talking about it. Ms. Wood, you'll be ready to go to trial?
Ready, Judge.
Okay, we've got crime lab results, all that kind of stuff.
Yes, Judge.
Okay, what's the issue in the case? Is it there were 3 people in a car or?
Co-defendants, Judge.
Okay.
So yes.
So the only person who ended up getting charged for whatever happened, if anything happened that day, was Mr. O'Neill.
The other people were charged. Their cases were dismissed for whatever reason.
Okay, I guess what I say, the only one left standing is, because it does look like a few things were dismissed as to Mr. O'Neill. Strangely, one of them is a possession of a marijuana with intent to distribute, and then a couple misdemeanors, but this still stands. Okay. Then we will see you on January 10th, Mr. O'Neill. Let me see.
I need to know what's going on.
Pardon me?
You'll come to my office and we'll go over everything, Judge, before
Okay.
the 10th.
Let me just look at your bond order. You wearing an ankle monitor still?
Yes, Sean.
Okay. Any reason we need to keep the ankle monitor on? It's been on for 1.5 years.
Same thing I'm trying.
So I wasn't asking you.
I wouldn't, say there's any reason, Your Honor, but I don't know if the ankle monitor is on because of his other two cases.
Well,
If it's on for this case, I can't see a reason why it should still be on.
okay, it's on for this case. So
Okay.
what I'd ask you to do, Ms. Wood, is get me a proposed order that removes the ankle monitor.
Yes, Judge.
We can deploy that to someone else who could use it. This one's been on long enough. You get that to me, I will sign that. And the only thing that'll change then is you won't have the ankle monitor, but you still need to stay away from Jordan Watkins, Latavius Hunter, and Nigel Ragland, and whatever's going on at 850 Oak Street. Where do you live?
Say 2230 Low Drive.
Okay. All right. Any questions?
I don't know.
Okay. You'll talk with Ms. Wood. Are you working these days?
Yes.
What do?
I sell shirts. I got a t-shirt company.
Well,
I do photography too.
losing the ankle monitor should help. All right. I'll take care of that. And we will see you on January 10th, if not before, if you guys sort something out. Okay.
Thank you, Judge.
All right. Take care. All right, so we've got a plea with Ms. Love. Ms. Love, if you'll come up, and then Ms. Willingham, do you have an update on Mr. Brashear?
Yes, Judge. It is my understanding we are going to do accountability court for Mr. Brashear.
Okay.
With that, I don't know, accountability court will be a term of his probation.
Sure.
Typically I've done them, the diversion track. So my question would be, do I still need to submit it before we can do the plea to make sure he's accepted?
Well,
I've never done this track before. So.
Understood. I'm sorry, Ms. Love, to leave you hanging there, but you assume for a minute he's not accepted in accountability court. Is it not going to be a plea, or should we?
Probation.
Okay, so my suggestion is that we take the plea, I accept the guilty plea, and we hold off on sentencing until we see if Mr. Brashear is accepted into, would it be BHTC or drug court or veterans court?
BHTC.
Okay, so we expedite the admissions work, and assuming they say, yes, we're ready for Mr. Brashear, then I could sign the final disposition that says it's a condition of your probation. But rather than build in a condition that he might involuntarily fail to comply with, but I'd like to take the plea so we know this case is resolved other than the final disposition. So let's do Ms. Love, and then we'll structure Mr. Brashear's situation.
Your Honor, if I may, I've done several, ones with pleas. And as long as you ensure that that the plea probation period is a minimum of 3 years, then you should be fine. I've done it like after the fact as well.
Okay, but what we don't know is if he'd be accepted. And so it'll certainly have to be at least 3 years probation, but this is very manageable, and it'll be sentence A or sentence B. But that way we can get it all on the record and take care of it. All right, position 13. 23 SC 188571, State versus Ms. Love. Ms. Love is here in court with Ms. Wood. Ms. Clark is here for the state. Ms. Love, you are charged in the indictment with aggravated assault and 3 misdemeanors. It may be through negotiations, these charges are changing, but I want to let you know what you're charged with. And Ms. Wood says you are ready to enter a plea in your case. Is that correct?
Yes.
Okay. In a moment, Ms. Clark's going to put you under oath. You'll raise your right hand and swear to tell the truth. Once you're under oath, it's important that you answer all of her questions and mine truthfully and completely. It's also important that if you have any questions because someone says something that doesn't make sense, or we're heading in a direction that's different from what you thought was going to happen, that you raise your hand or nudge Ms. Wood and say, I've got a question, so that I can answer it or Ms. Wood can answer it. Will you do that?
Mm-hmm.
Yes?
Yes.
Okay, great. And when you're answering questions, make sure you verbalize your answer. So you're welcome to nod your head, but you'll need to say yes or no or maybe, because the court reporter cannot take down or Okay? All right. When you're ready, Ms. Clark.
Thank you, Your Honor. Please raise your right hand. Do you swear or affirm that any evidence or testimony that you shall give in the matter currently pending before this court shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
You can put your hand. Please state and spell your correct legal name.
Quintisha Love, Quinteshia. Last name Love, Love.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Is there medication that you normally take that you have not taken or been given today?
No.
How old are you?
32.
What's the highest level of education or the last grade you completed?
11.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you've been charged with the following offenses? Count 1, aggravated assault. Count 2, battery, substantial physical harm. Count 3, cruelty to children. And count 4, cruelty to children.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
Do you understand that if you plead not guilty or remain silent, then the state is required to prove the charges against you at a jury trial?
Yes.
Have you had an opportunity to review the indictment with your attorney?
Yes.
And did you understand the indictment as explained to you by your attorney?
Yes.
Have you had enough time to speak with your attorney about all of the charges in the indictment against you, including the facts and circumstances relating to these charges?
Yes.
Are you satisfied with your attorney's services?
Yes.
Attorney Wood, do you waive a formal reading of the indictment?
We do.
Do you waive any defects in the indictment?
So waived.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes.
The state will provide those. For aggravated assault, the minimum is 1 year, the max is 20 years in prison. For count 2, battery, substantial physical harm, the minimum is 1 day in jail, the max is 12 months in jail. Count 3, cruelty to children, it's still the 1 to 12 months, and count 4, 1 to 12 months. Do you understand that your plea today is called a non-negotiated plea?
Yes.
And that the state may recommend a sentence to the court even without your having agreed to it?
Yes.
Are you aware that the state's offer in this case was 10 years probation with special conditions, behavioral incentive date of 4 years for count 1, for count 2, 12 months probation to run concurrent with count 1, and count 3, 12 months probation. Special conditions of probation, defendant must complete an anger management course within 60 days. No drugs unless prescribed, no alcohol, gainful employment, no contact with the victims Mila Miller and Zayden Kamek, stay away order from victims at least 200 yards, no references to the victims on social media or communication with third parties about the victims on social media.
Yes.
Okay. Have you discussed this offer with your attorney?
Yes.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge?
Yes.
Do you understand that if you enter a non-negotiated plea, you do not have a right to withdraw your plea of guilty once the court enters its sentence?
Yes.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes.
Are you currently on probation or parole?
No.
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
Yes.
Do you understand that if you fail to follow all the special conditions of your probation, then you will be subject to revocation of that probation for the balance of your sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Do you understand that by entering a plea of guilty today, you're waiving all defenses, including any mental health defenses?
Yes.
You understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to subpoena witnesses on your behalf, the right to testify or offer other evidence, the right to assistance of counsel, the right to the presumption of innocence, the right not to incriminate yourself, and the right to appeal if convicted of these charges at a trial? Is it your decision to waive these rights, which means not to use them, and to enter a guilty plea today?
Yes.
Has anyone forced, threatened, coerced, or promised you anything to get you to enter this guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
No.
Are you pleading guilty because you have decided that it is in your best interest to do so?
Yes.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes.
As to indictment number 23 SC 188571, how do you plead to the charge of aggravated assault?
Guilty.
I didn't hear you.
Guilty.
How do you plead to the charge of battery, substantial physical harm?
Guilty.
How do you plead to count 3, cruelty to children in 3rd degree?
Guilty.
And count 4, cruelty to children in 3rd degree?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that if you wish to file a direct appeal, you must do so within 30 days from today's date?
Yes.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes.
Do you understand that for felony charge, you have only 4 years from today's date to file that petition?
Yes.
Do you understand that for a misdemeanor charge, you only have 12 months from today's date to file that petition?
Yes.
At this time, Your Honor, the state will provide a factual basis for the plea of this case. On February 20, if this matter would have went to trial, the state would have been able to prove beyond a reasonable doubt that on February 24, 2021, APD officers were raised by Zone 5 to respond to an information on a dispute call at Grady Hospital. Once on scene, officers made contact with the victim, Miss Mila Miller. Unit 2512 was able to give basic information on the events that occurred. Officers were able to speak with the victim, Miss Mila Miller, who stated that she was assaulted by the mother of her boyfriend's children, the defendant, Miss Quenisha Love. Victim Miller stated that she had returned home from running errands in the early afternoon with her children and the children of her boyfriend, Mr. Lamont Wheeler. Once returning to the location and having been home for approximately 10 to 15 minutes, the mother of Mr. Wheeler's children, the defendant, Quenisha Love, arrived at the apartment unannounced and unwelcome and began banging on the door. Victim Miller advised while defendant Love was
Hey, Ms.
banging
Love,
on
just
the door,
sit tight.
she was also shouting obscenities and making the children scared. After a few minutes of banging on the front door, defendant Love then went around to the back door of the location and was able to force her way into the location through the back. Once inside the residence, defendant Love cornered victim Miller inside the restroom and began punching her multiple times in the head with a closed fist. While still getting punched in the face multiple times, victim Miller at some point fell to the ground inside the bathroom. Defendant Love then mounted on top of victim Miller and continued beating her with closed fists and shouting, "I'm going to kill you, bitch," several times. Defendant Love then was able to pick up a loose floor tile and smash it into Miss Miller's face, causing a laceration to her right eye. Miss Love then stood up and left the apartment in an unknown direction. During the course of this attack, defendant Love's children, Kamoni Love, Quadarius Wheeler, and Kanijah Wheeler were all present in the room. Also in the room were victim Miller's children, Maya and Zayden Kamek. These children were witnesses to the entire attack from start to finish. Ms. Miller contacted her mother, and defendant ultimately was arrested in this case. Your Honor, I've spoken with the victim in this case, and she wants the defendant to be held accountable, but she is definitely afraid, still afraid of this defendant. There were medical records, Your Honor, in this particular case, and there was significant damage to the defendants right above her eye. So there was damage viewable on the body camera footage as the victim was speaking with the officers, providing her account of what happened. And she is visibly scarred, seen visibly scarred in the body camera footage. It is the position of the state that if this matter would have went to trial, we would have been able to prove the facts as to support the charges indicted.
So the part I didn't follow was the connection between Ms. Miller and Ms. Love. It was the mother of the boyfriend's kids, but who?
So apparently Lamont Willer is the boyfriend of our victim.
Oh, okay, so in February of 2021,
yes,
according to the information you have, Ms. Miller and Mr. Willer are an item.
Correct.
But at some point in the past, Ms. Love and Mr. Willer had been an item because they had kids together.
Exactly.
Okay.
I think 2 kids.
So there's a complicated triangle.
Okay.
All right, got it. And so the connection is Mr. Willer.
Yes.
And Ms. Love brought her kids with her, or her kids through Mr. Willer were already there because Ms. Miller was at Mr. Willer's location? If you know.
I don't know that. I don't know
Okay,
that part.
it's not central. All right, got it. Okay, thank you. Let me hear, please, from Ms. Jackson. Good morning, Ms. Jackson.
Good morning, Your Honor.
Did you have a good Thanksgiving break?
Yes, I did. Yourself?
I did, and I'm glad you decided to come back.
All right, thank you.
So what criminal history information do you have for Ms. Love?
Okay. She has 3 cycles. The last arrest was May the 4th, 2019, with the City of Atlanta Police Department for felony obstruction and simple battery family violence. There was no disposition for that arrest, and there are no convictions listed in the GCIC. Nothing in addition.
All right, thank you. So Ms. Wood, I certainly want to hear from you, and if Ms. Love wants to provide a different perspective on what happened, I'm happy to hear from her. I didn't hear first offender. Is this a first offender?
I'll be asking for first offender, Judge.
Okay, great. I'll talk about that with Ms. Love. What do you want to add?
Thank you, Judge. Ms. Clark mentioned medical records. That's news to me, Judge. The document that I have in discovery says from Grady that they regret to inform the state there's no evidence of the above named patient being treated at Grady Memorial on these dates. So I did not see any medical records. I'm just going off of the allegations of injuries provided solely in the police report.
What about we set that aside, but the body cam video, are you able to
I
see?
do have the videos, Judge.
Ms. Miller looks like she's got a bump over her eye, or there's blood there, or?
Yes, Judge, but I was confused because the call came into Grady, so I'm not sure what happened or if there are medical records, but
Okay.
In any event, Miss Love is eager to put this behind her and move on with her life, which is why we are entering a plea today.
Sure, we're almost 3 years into it.
Correct, Judge. She's had no arrests since this incident. She has a very small criminal history. She is 32 years old. She has 4 children, as you heard with Mr. Wheeler. She has 1 child on the way. Judge, I actually heard from Mr. Wheeler in the hallway. I spoke to him on the phone. I saw text messages. He and Miss Miller are still together. They've all moved on from this. From the text messages I saw, they were very confused as to why this was still hanging around. Of course, we explained that the state can move forward whether or not, but I did think it was important for the court to know that they said, hey, we're chill, we moved on. Miss Love and Mr. Wheeler co-parent successfully together. She has no interaction with Miss Miller. So I think that's important for the court to understand. Judge, I am asking for first offender treatment. I'm asking for 3 years probation, given her lack of criminal history and the fact that this seems like a one-off incident. I think no violent contact with Miss Miller and her children is appropriate. I don't think a complete stay away is necessary. I also don't think a special condition of no alcohol is necessary, as alcohol doesn't seem to be a factor in this incident. Also, I would ask the court not to impose the special conditions of no references to victim on social media. And probation is going to ask that she maintain gainful employment. So I don't know if that's necessarily needs to be a special condition. So we are asking for 3 years probation, first offender treatment, and no violent contact with the victim's judge.
So what Mr. Wheeler told you is that he and Ms. Love are sorting out their own parenting situation.
Right.
He and Ms. Miller are still an item.
Yes.
These almost 3 years later, and that he hasn't seen any issues since February 21 with Ms. Love doing something like this.
Correct.
Okay.
They actually stayed down the street from me, so I'm kind of
They
trying to figure out how she's fearing for her life, but you come move down the street in his brother's house. So I'm lost at that.
Well, it may be that that's the most convenient place for her to live, but
She don't want to respect her sister, so her sister put her out.
okay, but that could be part of it too. But you are going to need to leave her alone.
I don't go nowhere near them. I tell you, they stay right down the street from me. He bring my kids to me.
Good. That sounds like you've got a good plan. It shouldn't be much of an issue, although I'll tell you, you seem to get kind of ramped up pretty quickly. I don't even know you. We've been talking for 5 minutes and you're pacing around and acting angry. So that makes me worry a little bit about your ability to keep your cool if life gets complicated and Mr. Wheeler doesn't treat you right and you go to where he is. That'll be a problem.
I don't go there.
Okay, well, that'll be how it needs to be. When you say right down the street, what street do you live on?
Windsor.
Windsor?
Mm-hmm.
And what street does he live on?
On the other side of Windsor.
So his address is,
No, it's like a side street, but it's right there.
okay. Like if you were gonna walk from your place to his,
It'd take me like 5 minutes.
who lives with you?
For me, my boyfriend, and me.
Okay. None of your kids stay with you?
Yeah, they'd be there.
Okay.
They just look when they like to stay up on his house. So it's just right down the street. So they school still. Right.
Yeah, they can bounce back and forth pretty easily. And you're gonna have another kid soon?
Yes.
When is that?
I don't know yet. I just found this out on Thanksgiving.
Well, congratulations. Is it not good news?
No, but then again, yeah.
Okay. But it sounds like that's a little ways out if you just found out. It's not like in 4 months, it's gonna be a bunch of months.
Mm-hmm.
Okay. All right. Do you have any questions about anything we've been talking about?
No.
I need to talk to you a little bit about first offender. That is an opportunity that you have because you haven't really been in trouble before. You certainly don't have a conviction. If you take a first offender sentence, it's also not a conviction. So when you leave here today, you're not a convicted felon. If you successfully complete your sentence, which means in large part, you stay away from Ms. Miller and don't get mixed up with her in any way. So if you successfully complete your sentence, when you're done with your sentence, the whole thing comes off your record. It's really not on your record right now. No one could look at your record and say, oh man, she's got this conviction, because you don't. You'll be what we call a first offender probationer. So you'll have a sentence, but you really don't have a conviction. That helps with work, with school, whatever you might want to do. And so, like I said, it's generally an opportunity. There is a downside. And the downside is that if while you are on this sentence, you mess up, you get angry, you smack someone with a floor tile, whatever it is, not only would you have a new case, but you'd come back here and I'd need to figure out, was it a mistake to give you first offender? And if I decide that, I could resentence you as a felon because you've pled guilty. And I have a lot to work with. You heard Ms. Clark describe the ranges here with aggravated assaults up to 20 years. And so I'm making this up entirely. But if 2 years from now, you poke someone in the eye because you get angry, I could say, we just misread this whole situation, Ms. Love. I'm gonna sentence you to 5 years on this old situation with Ms. Miller. Even if the person you poke in the eye isn't Ms. Miller, it's Fred Jones. So first offender works well if you're gonna stay out of trouble and you're not gonna lose your cool and get angry at someone and shove them around. So if you think you can do it, then first offender is a good thing. If you're a little worried about people pushing your buttons and how you react and what you do when things aren't going the way you like, then first offender is a bad idea. Because if you end up in the back of a police car again, then you're going to end up in here and it will be a less happy outcome. But you know you, I don't. I'm meeting you for the first time. You apparently like the Atlanta Hawks. I'm not going to hold that against you. But do you want to be treated as a first offender?
Yes.
Okay. I will sentence you as a first offender. I find there's a factual basis for your plea and that your plea is knowing and voluntary. Knowing means you've understood what we talked about. No questions about anything?
No.
Voluntary means that even though you're not real excited to be here, no one has forced you to enter this plea, but you're doing it because you've had a chance to talk with your lawyer and you think it's the right way to move forward. I'm sentencing you pursuant to the Probation Options Management Act. And all that means is that while you're on probation, if you have a technical violation, maybe you miss a meeting with a probation officer, you and probation can sort that out. You don't have to come see me. But if it's more serious, you get arrested for something, then you're going to come see me because getting arrested for something is a violation of your probation. I'm going to sentence you to 5 years on count 1 and 12 months each on counts 2, 3, and 4. I will run them all concurrently with each other. So that's a total of 5 years probation. I'm going to set a behavioral incentive date of 3 years from now, which would be November 28th of 2026. What that means is if you've done fine on probation over the next 3 years, they can close your case out. If you've had struggles with that because you get arrested or you're not reporting or this or that, then it'll be all 5 years that you'll need to do. But if you're heading in your direction and you let Ms. Miller do her thing, whatever her relationship is with her sister, then you'll be all set after 3 years. Special condition of probation number 1 is no violent contact with Ms. Miller. It may be because you guys live so close together and because your kids are bouncing back and forth between a household in which she lives and one in which you live, that you actually end up being near her. It doesn't mean if you see her on the street, you have to run away, but it does mean you just stay out of her business. And I'll tell you, if she has a cell phone recording of you hollering at her, that's going to be the kind of thing the state's going to bring to me. And I'll say, what do you not understand about leaving her alone? So don't be fussing at her, even if she makes your life complicated. Now, it's not meant to be a trap. If she comes banging on your door, fussing at you, you need to let Ms. Wood know, hey, this lady's not leaving me alone. And I'm going to defend my household. So Ms. Miller needs to leave you alone as well. But the main burden is on you as between who's going to leave the other one alone. Okay. You'll also need to take an anger management course. I'm going to give you 90 days. That's 3 months. Take that anger management course. So if we are in April or March of next year and you haven't taken it yet, that's a violation of your probation. They may write you up and then we're going to need to talk, and let's avoid that. So take that class and take care of business. I know you had some other conditions. The gainful employment is something that probation will take care of. Anything else in terms of interacting with Ms. Miller? Ms. Clark, are you good?
I just think based off of the situation that neither the victim or the defendant should be able to talk about each other on social media. I think social media is a catalyst to a lot of other things.
I think that's a fair observation. I don't know how active you are on social media, Ms. Love, but you should refrain, no references to Ms. Miller on social media. So whatever you're posting, writing, tweeting, Xing, TikToking, it can be about anything else in the whole world other than Mila Miller. Understand? Is that going to be complicated?
No, my page is a business.
Your page is a what?
It's my business page.
What is your business?
I do food and cakes. I do catering and cakes.
What kind of cakes?
I bake cakes.
What's your business called?
House of Love.
House of Love. We had as a juror not that long ago, was it called the Cupcake Pimp?
The pimp, yes.
Yeah, but PIMP, it was like perfect ingredients make, pure ingredients make perfection. Amazing cup. He brought some in. They were great cupcakes. They were real good. but you've got a baking business as well. That's fantastic. Good for you. That's your sentence. You are going to need to sign up with probation, and Ms. Tucson is on this call. I'm going to ask her to engage with you for a moment and let you know what you need to do. Ms. Tucson?
Morning.
Morning.
Okay, Miss Wood did send me an email, so I appreciate that. Did I hear you say you weren't gonna upload the disposition as of yet, or just so?
No, this case I will. That will be uploaded. I mean, once I get it from Ms. Nelson, I'll sign it. We'll be taken care of. It's the next plea we're taking that we're holding off on because of the possibility of accountability court.
Okay, all right. And Miss Love, I just want to confirm you do live in Fulton County?
Yes.
Okay, and I will be contacting you at 678-973-9707, correct?
Mm-hmm.
Okay, that because you will have a probation officer reach out to you for your intake, and then I will also send you the reporting instructions. Okay. Do you have any questions for me?
Yes, if I don't answer, can you guys leave a message or text me? Because I'm either probably at work and can't pick up the phone because I do.
That's no problem. I'll text you my number and you can call me when you're available. That's no problem.
Okay.
Okay.
All right. Thank you, Ms. Tucson. Ms. Love, any questions about anything?
No.
All right. Good luck. Ms. Clark, thanks for your help. I will see you at 1.
Yes, Your Honor.
All right.
Thanks. Thank you, Judge.
You bet. I'll see you at 1.
Yes. Sorry.
Ms. Feely, are you ready for Mr. Brashear? Okay. You guys want to come up to the podium? Was Mr. Walker supposed to be on a final plea coming up?
On the 30th.
Okay, got it. Because there's this work here lining up folks for the other thing. And someone just said, well, they were going to be here on Thursday. I'm like, I hope not. But they were going to be here. It takes a while to calendar them. So we'll work through that. Okay. All right. Are you ready?
Yes.
Okay, let's get on the record. This is position 11, 23 SC 188396, State versus Brashear. Mr. Brashear, you are charged with arson. You're here with Ms. Feely, your lawyer. Ms. Willingham represents the state. And it's my understanding, Mr. Brashear, that you're prepared to enter a plea in your case. Is that correct?
I don't know yet.
Okay. When you say you don't know yet, what do you mean by that?
Well, I mean, that's talking about giving me 5 years. I don't know about taking 5 years.
Okay. Well, where we are today is that we can have a conversation about your plea, and then I'll tell you what sentence I'm going to impose. And if you don't like it, and it's more than what your lawyer had asked for, then you can say, I don't want that. No, thank you. And you'll be able to go, and we can get you a trial. It sounds like to me that the two sides are pretty close. So I don't think you're going to be surprised by how this plays out. But I want to reassure you that after I tell you what I think the sentence is going to be, you'll get to talk with your lawyer about it to say, okay, I'm good with that. If I go along with what your lawyer says, you don't get to change your mind. So if your lawyer is asking for, I'm making these numbers up, 4 years or no jail time, but some probation, and that's what I go along with, you have to live up to your word on that. But if I surprise you and say, oh man, arson, I'm gonna sentence you to 10 years of prison, you're gonna say, that's not what I thought was gonna happen. No, thank you. And you'll get to go and we'll bring you in for a trial. But it doesn't sound like that's where we're heading. Okay. So you're welcome. But it does sound like you're ready to have that discussion about pleading guilty. Is that correct? Yes?
Yes, sir.
Okay. When you're ready, Ms. Willingham.
Judge, I'm sorry, just for clarification, because it was my understanding when I came back up that we were entering a negotiated plea. My recommendation for a non-negotiated plea is very different from a negotiated plea. So I just want to make sure we're on the same page.
Okay.
I've talked with Mr. Bashir about the 5, so I don't know if that needs to be more of a discussion.
Well, it's 5 years probation. Is that what we're talking about? It's not 5 years in custody. The negotiations
Correct.
were for Mr. Bashir to plead guilty to arson and be sentenced to 5 years on probation. The main condition being, there may be some safety conditions as well. I'll hear more about the case, but the main treatment condition would be that Mr. Bashir enter into and complete behavioral health treatment court. That requires a sentence of at least 3 years probation anyway. We're just building in a little extra time because BHTC can take longer than the other accountability court tracks because there's more that the clients are juggling. So I'm not committing to anything right now, Mr. Bashir. I need to hear more about you and this alleged arson, et cetera. But it sounds like you and your lawyer had agreed, well, hey, state, if you're willing to say 5 years probation, no jail time, and get me some of that accountability court treatment, maybe this makes sense. Is that a fair statement or am I mistaken?
Yes, sir.
That's okay?
Talk to him about it. Yes, sir.
And I think he was interested in a potential incentive date of 3 years, which is slightly different. I don't know.
Oh, okay. If that's where I'm okay with that.
Okay. Well, and the other thing that happens is often, not always, but often, that occurs because of graduating from accountability court. Typically, the judge handling that accountability court track signs an order terminating probation upon completion of accountability court. Circumstances vary, and it may be that everyone agrees a little additional supervision post-graduation makes sense. Those will hit about the same time. If Mr. Bashir does real well in accountability court, he might graduate a little before 3 years. So it would make sense to bake in a behavioral incentive date as well, in case a decision is made to keep him on probation after he graduates.
Thank you. And I also should point out, I think we're ready to go. I do think that there is going to be some struggle here. Mr. Bashir does have some memory issues, and as you can tell, some other cognitive, certainly not to the level of competency, but just
sure. Okay. Well, let's try to make the plea work. Mr. Bashir, Ms. Willingham's going to put you under oath and then ask you a bunch of questions. They're not trick questions. They're questions to make sure you understand what's going on. If at any point you're confused by what someone says, let Ms. Feely know and she'll explain it to you, okay?
Thank you, sir.
All right, let's do it.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. Please state your name, your age, and your date of birth.
John Henry Bashir, November 18th, 1976.
And your age.
47.
Are you now under the influence of any medicine, drugs, or alcohol?
I take medication.
Is the medicine you have taken been prescribed by a doctor?
Yes.
Have you taken it as prescribed?
Yes.
Does anything about the medicine inhibit your ability to understand the proceedings today?
I don't think so.
How far did you go in school?
10th grade.
Can you read and write in the English language?
Yes.
Have you had the opportunity to review the document that charges you in this case?
Yeah, I just looked at it.
Do you fully understand the nature of the charges pending against you?
Yes.
By pleading guilty today, you are giving up certain rights. The right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand these rights?
Yes.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury? The negotiation in this case is that you would enter a plea of guilty to arson first degree, which has a minimum of 1 year and a maximum of 20 years. You would be sentenced, you would be required to serve 5 years on probation. And as a part of that probation, you would be required to complete accountability court should you get accepted. Should you not be accepted at that time, we would come back and add provisions for that sentencing. Is that what was explained to you?
No.
So it just means the probation that we just talked about with the accountability court program, the behavioral health program that you would participate in, that is a application-based program. So if you apply to it and for whatever reason they don't accept you, we're going to come back and we would give you terms, but it would still be probation. It would not be, I'm not going to come back and say, because he didn't get in accountability court, I want him to go to jail for 5 years. It's still going to be probation. We would just have to come up with a different treatment plan for you. Do you understand that?
Yes.
It also wouldn't be any longer of a sentence.
Correct.
So the recommendation is 5 years probation. The goal is to get you into accountability court.
Say something.
Yes, sir.
I'm already under care through mental health. I don't know what you call it, provider.
Good. Well, that's something that accountability court will not interfere with that. It will be in addition to that. So I'm going to hear a little bit more about your case, but that may be that alternate sentence. If accountability court doesn't work out for some reason, if they say it is not going to work, then what I may do is make a condition of your probation that you continue to get the care that you're getting from this other provider.
Yes, sir.
Okay. Let's keep going.
Okay. You're pleading guilty today to arson first degree with a minimum of 1 year and a maximum of 20 years. Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
Nope.
You heard me tell the court that the negotiation in this case is 5 years probation. Do you understand the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law, which is 20 years in custody?
I understand.
Do you understand, however, that if the court does not accept this negotiation and sentences you higher than what your attorney is asking, that you would have a right to withdraw your guilty plea today?
Yes.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. You will be required to follow the general conditions of probation that probation will give to you when you meet with them, including, but not limited to, that you are not to violate the criminal laws of any governmental unit. Under the special conditions, you would be required to complete the accountability program, behavioral health treatment, if you're accepted. Do you understand that a violation of and no contact with the victim in this case? Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes.
Are you entering your plea of guilty with an understanding of everything we just talked about?
I suppose.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No.
Are you satisfied with what your lawyer has done for you in this case?
Not really.
So let me pause you there, because if you think that your lawyer has somehow not done something that she's supposed to, we have to work through that. I've worked with Ms. Feely for several years now and know that she works pretty hard on behalf of her clients. Is there something in particular that you're concerned about? I mean, here you're charged with arson in the first degree, which is something that usually results in people going to prison. And Ms. Feely has been able to negotiate a sentence for you where you don't go to jail at all. At best, you'll be getting some additional treatment. What's the part you're unhappy about?
Well, I have no recollection of this and I've seen no evidence that I did this. So for me, it's a little bit hard to plead guilty to something that I don't even know that I've done.
Got it.
One more time to speak with me.
I mean, it's just difficult for me because like I said, I don't remember the incident.
So,
I've seen one shred of evidence that says that I've done it, so.
All right, we should probably pause for a little bit so you and Ms. Feely can talk about that. You not remembering it doesn't necessarily mean we can't go forward, depending on what you look at. And there's always what we call a best interest plea, an offered plea, where the defendant, that would be you, says, look, I don't necessarily agree with what the state says happened because either I have a different recollection or I don't recall it. But I've decided that this is the safest way forward for me. So it may be that Ms. Feely has some things she can tell you about it. Maybe she's already told you about some things that would cause you to say, huh, if a jury heard about that, they might well say Brashear set this fire. And so I'd rather not get in front of a jury with that and put my family through that situation. And here's a chance for me to get some help and not go to jail. But that needs to be a decision for you to make, not for me to make. Do you want a few minutes to talk with Ms. Feely about the evidence?
Yes, sir.
Okay. Ms. Feely, are there things you think you've got that you can share with Mr. Brashear or his family that would address that particular concern?
I think this might be the memory issues, but
Yeah.
I can go back over.
Okay.
I have it pulled up.
Okay, and maybe if you just do a right to hear, because if you see it and then say, oh, right, that thing, that I understand the connection.
Do you remember the 911 calls we listened to?
No.
Okay. And the videos?
I remember, yeah.
Okay. So that's the evidence. You want to talk in privately? I might need to sit out with them.
Okay, we'll pause. I didn't understand, Ms. Wood, what Ms. Love was somehow not happy about being, that the kid was coming. Was it a health thing or was it like, oh, it's awkward, it's not Mr.
Financial.
Okay, not good timing.
Yes.
Judge, I think I'm gonna have to go back to the table.
Okay,
My computer is going to die.
battery dying. Okay. We had to relocate Ms. Willingham. Her computer was dying. Hopefully that microphone is on. I can't get that camera to work, but that's okay.
Microphone's on though.
You'll be audio only.
Okay.
All right, let's pick up where we left off. Let me check one thing first. All right. So, Mr. Bashir, there was a question about whether you were satisfied with the work Ms. Feely had done. And one of the concerns you had was you just didn't remember much about this fire that was set. And Ms. Feely had alerted me at the beginning of our conversation that you have memory problems and you'll forget things that you read or see or do. Did you have a chance to review some of the evidence in this case that maybe makes you more comfortable moving forward with your plea?
Yes, sir.
Okay, great. Ms. Willingham?
Do you have any more questions for your lawyer before we go on?
I think we got it straightened out.
Okay, can you say it a little louder?
I think we got it straightened out.
Great, thank you.
Have you understood everything I have asked you so far?
Yes.
Understanding all of your rights, do you wish to enter a plea to this charge today?
Yes.
Is your decision to plead guilty made freely and voluntarily?
No.
I think what's tripping him up is we did discuss before we came up here, and then Your Honor discussed it a little bit again with him, the offered plea because
Sure.
of memory issues.
Yep. So we can certainly do an offered plea, but your plea, whether it's an offered plea saying, I don't agree with everything the state says because I don't remember it, or a regular plea saying, yep, that's what I did, I plead guilty. It still needs to be a voluntary plea, because if it's involuntary, someone's forcing you to do it, your lawyer's saying, you better do it, or I'm going to tell them what you told me, or the young lady in court is saying, you better do it, or you're in trouble. I can't take that. You're going to need to go away and come back some other time. But if we're here because this is how you've decided you want to move forward, that's voluntary and we're okay.
I understand that.
Okay, so this is a voluntary situation?
Yeah, but I'm not pleading guilty.
Okay, you're going to do this offered plea?
Yes, sir.
Okay, so your plea is still voluntary, but it's an offered plea.
Yes, sir.
Got it.
Are you entering your plea of guilty pursuant to North Carolina v. Alford, meaning that you may not admit guilt to every element of the crime charged, but believe it's in your best interest to plead guilty today?
Yes.
Are you a United States citizen?
Yes.
If you wish to challenge this plea for legal error, you have one of two ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is the habeas corpus petition. You will have 4 years from the date the sentence is entered to file this petition. Do you understand these time limits?
Yes.
Do you understand that you are not allowed to possess firearms during the course of your probation?
Yes.
Do you understand if you are found in possession of a firearm, you could be charged with another felony, which carries up to 10 years in confinement?
Yes.
If the state were to proceed forward with trial, the state would prove beyond a reasonable doubt. Well, I'm sorry, Judge, I'm going to get to a more concise version of the facts.
Okay.
That on October 8th, 2021, officers were dispatched to Monroe Drive Northeast and Piedmont Avenue Northeast in reference to a vehicle on fire. Upon arrival, officers met with Fire Unit 29, who were already on scene and had the vehicle fire under control. The incident occurred at the Shell gas station on 1539 Piedmont Avenue Northeast. At that time, the officer was approached by the caller, William Matthews. Mr. Matthews stated that he saw a white male, black hoodie, blue baggy jeans, and black sunglasses pour gasoline from one of the pumps into the trunk of the vehicle. drive away from the pump, throw something into the trunk. The vehicle ignited, and then the driver casually walked north towards the Octopus Kitchen. Officer spoke with security outside the Octopus Kitchen, and the man was not seen in the area. The officer then went into the Varuni Napoli restaurant next to the Octopus Kitchen, and the driver was seen walking in, asking for water, and then walking back out. Officers were not able to view the camera footage at the location, officers were able to view the camera footage at the location. No management staff was available at the time. Further, the officer was able to check the vehicle tag on the vehicle that was reported on fire, and they determined that the vehicle was not stolen or reported stolen. They could not find contact information for the owner of the vehicle because the vehicle and the owner were both registered in New York. The owner of the Shell gas station stated that she could not get access to the cameras at the time and needed to contact the IT tech who can access the cameras and at the location. Ultimately, officers were able to view that camera footage. They also were able to make contact with the victim in New York, who stated that the defendant had taken her vehicle and that he had set it on fire. And subsequently, when officers were able to view the camera footage, it was Mr. Bashir, which is someone that she knew. So she was able to determine that that was in fact him in the video footage that officers were able to see. And based on that, Your Honor, the state believes that if we proceeded to trial, we would have enough to prove beyond a reasonable doubt that Mr. Bashir actually set the fire to the victim's vehicle in this incident.
So your involvement in the case, Ms. Willingham, is because of the connection Mr. Bashir had with the owner of the car?
Yes, Judge. And it appears they had a relationship. And actually, when our office spoke with her back in June, she was actually quite frustrated that the defendant got out on bond without us speaking with her. However, I have contacted her multiple times since then and have not received any calls back. We have confirmed that the number we have is still correct. But based on that, if this case were to proceed to trial, obviously we have ways of getting her here.
Sure.
But considering some of the other mitigating factors, I do believe this is a reasonable resolution at this time.
Okay. And is she still in New York?
Yes.
Okay, that makes it easier if Mr. Bashir is going to be staying in Georgia.
Yes.
Okay, got it. Thank you. All right. Ms. Jackson, tell me what you have in terms of criminal history for Mr. Bashir.
He has 31 cycles. The last arrest was August the 5th, 2021 in Bleckley County, Georgia, for driving without a valid license and a DUI. Those charges were dead docketed on March the 20th, 2023. He does appear to have an open probation case. That case number is 11 SC 98495 for 2 counts of aggravated assault and robbery. That disposition date was May the 21st, 2012. Confinement 9 years, probation 6 years, and he does have prior felony convictions. This one in 2011 out of DeKalb County for criminal attempt to commit a felony. One in 2007 out of Texas for possession of controlled substance. And one in 2004 out of Texas for assault. One in 1997 out of Texas for burglary. And he does have misdemeanor sentences and convictions. He received a nolo contendere sentence in 2020 out of Gwinnett County for driving without a valid license. There was one in 2012 for simple battery. And there was one in 2010 out of Doraville, Georgia for fleeing or attempting to elude an officer. And he received a nolo contendere sentence in 2009 out of Addersville, Georgia for driving while license suspended or revoked. And I apologize for being out of order, Your Honor. It does have it was one conviction in 2010 associated with a CWAC. And he received a no contendere sentence in 2007 for possession of marijuana less than an ounce. And he has a history out of New York as well. It was a 2007 charge associated with a CWAC. There was another one in 2007 out of New York for a DUI. Nothing in addition, Your Honor.
Thank you. Ms. Feely, we have one little wrinkle that I think we can manage. That Fulton County case that Ms. Jackson referenced is open, and there's actually an active probation warrant in it that Judge Glanville signed long ago, most of which it sounds like has been addressed, not through the form of a revocation, but that arrest in Bleckley County for the DUI and no license has been dead docketed. That was part of it. And then Mr. Brashear purportedly tested positive for a number of substances back in 21. It's an old warrant. It's all consistent with getting him into an accountability court. So I'm inclined to manage that. But I just needed you to know that that hit my radar while we were talking.
Yes, we'd like to wrap that up as well.
Okay.
You ready for me?
I'm ready for you.
Thank you. So Mr. Brashear is 47 years old. He has 3 children and 5 grandchildren under 8 and 1 on the way. They live in Texas, and he saw them last week for the holidays.
Meaning he went to Texas?
He did go to Texas.
How did you get to Texas?
My friend took me.
Your friend took you, as in drove you?
Yeah, so.
Okay.
And I was going to speak about Miss Jimmy Allen. You've heard the criminal history. Most of it is old. When Mr. Brashear got out of prison, he has been really trying to turn things around, and Miss Allen has been helping him do that. And she's the one who got together the packet of documents that I shared with Ms. Willingham. He is not able to work, but he had his first disability hearing last month. We don't have the results of that yet. But he also has a driver's license for the first time, as well as a car. I've shown this to Ms. Willingham as well. If I can approach, I think the picture on his driver's license is kind of indicative of where he is at this time. He's very, very proud of the progress that he's made.
Fantastic. Good for you.
Thank you, sir.
So hopefully that will.
The address in Marietta, is that where you live?
Oh, yes, sir.
Who lives there with you? Okay, great. It's good to have a license. You'll avoid some of this other stuff.
Yes, sir. Thank you.
We're getting picked up on things like that. So we asked the court to accept this plea. Mr. Brashear did want me to ask for the incentive date because he does intend to continue his upward trajectory. And so he was hoping that his probation could terminate if everything went well after 3 years. But other than that, this is negotiated.
Are the conditions that Mr. Brashear is working through that would qualify him for BHTC and require the medications, are those lifelong struggles, or was there a catastrophic event partway through his life that led to that? Or what can you share with me that he's comfortable having you share with me?
So not that I know of, but I will say Mr. Brashear does have trouble being a historian, and he's really our only source at this point. But I know that it seems like it's been lifelong.
Okay, got it. Mr. Brashear, do you have any questions or anything you want to add?
No, sir.
All right. And I trust that Ms. Allen is not the person from New York whose car was set on fire. That's a different individual, Ms. Willingham?
I'm sorry, Judge.
The person here in court?
No, that's not the complaining witness. No.
Okay, got it. Okay. All right. Well, Mr. Brashear, I find that there's a factual basis for your plea. I know it's an offered plea, but based on what I heard from Ms. Willingham, I think if there was a trial, the state would have enough evidence to convince a jury that you did in fact set this person's car on fire. That's not me saying you did do it. That's not my call. But if witnesses came in and looked at the videos and this and that, a jury could say, yeah, this guy, he poured gas in the trunk of the car and he set it on fire. Fortunately, no one was hurt. And I will accept it as an offered plea, but I do find there's a factual basis. I also find that your plea is knowing and voluntary. Knowing means that after you ask your good questions, you understand what we're talking about. And voluntary means no one's forcing you to do this plea, but you've decided that the right way forward for you is to enter an offered plea to this arson charge. Is that a fair statement?
Yes, sir.
Okay. I'm sentencing you under the Probation Options Management Act, and all that means is that while you're on probation, which you will be for a few years, if you have a small violation, you and probation will work through it. But if it's a big violation, you get arrested again, DUI, something like that, that comes back to me and we'll figure out what the consequences ought to be. I am going to follow the negotiated resolution and sentence you to 5 years probation. Special condition of probation number 1 will be that you enter into and successfully complete the behavioral health treatment court through our accountability court. Now, you have to be admitted into that. If you aren't, then I'm going to issue a new sentence. You're not going to be in trouble. It's not you doing anything wrong, but it may just be it's not the right fit. That doesn't mean you're a bad person or a good person. It means it's not the right fit. And then I'll need to do a different sentence, and we'll do that. But the sentence I'm going to do right now, I know I talked about, I'm going to save this sentence or that. The sentence that I'm going to do is the behavioral health treatment court one. If they say it's not going to work, then we'll need to figure out a different plan. It will not involve jail. It will not involve more probation. It will always be 5 years probation. So the special condition will be number 1, that you complete behavioral health treatment court. Number 2, that you continue to take all medications that doctors prescribe. They say, take this medication, get that shot. You got to do that. You're not the doctor. You do what the doctors tell you. I will set a behavioral incentive date of November 28th, 2026. That's 3 years from now. And Ms. Tucson, if I want to set aside the warrant in the 11 SC case, am I able? I know I can do that. What do I need to say to get that set aside? Let me ask a different question. How much time remains in that case?
I was going to say, I think perhaps a revocation order. He has 2 years, 1 month, and 2 days remaining on that 11 SC case.
Why don't I do this? I'll make sure it works with Ms. Feely as well.
Or cancellation.
No, I'm going to do a revocation order, but what I'm going to do is find that this new conviction violated Mr. Brashear's probation from that old case. So I'll revoke, but what I'll do by revoking is simply add the special condition to the 11 SC case that he enter into and successfully complete accountability court, specifically BHTC.
Okay.
Can we do that?
Yes, and it will need to also be on the final disposition, because they do, the DA refers it to BHTC, or the defense attorney does.
In the past, I think the DA has, but
It can be either one. I can send it though.
Okay, we'll have it come from Ms. Willingham. It can be either one. But when you say on the final disposition in this case?
No, the 23 SC.
Yeah, right. Okay, we're talking about the same thing. Okay. Do you need any information from Mr. Brashear?
I will confirm what I have on file. Do you have your officer's number, Mr. Brashear?
Your probation officer's number?
No.
He doesn't seem to have that. Okay, I could either give it to you now, or I could give it to Miss Wood. It looks like, I'm sorry, Miss Feely, you have Officer Cook. And are you on 1478 North Druid Hills in Brookhaven?
What?
the address is in there now. Okay.
No.
Marietta?
Marietta.
Yeah, we've got a different address. It's now
Okay, well,
8.
I will need the updated address and phone number.
Okay, I'll let Ms. Feely send that to you, but it's in Marietta, so it's going to be Cobb County Supervision.
Okay. Then, do you know where the office is in Cobb, Mr. Bashir?
No.
He does not.
Okay. Okay, so I'll have to call you and give you that information because since your case is still here in Atlanta, you're gonna have to contact Officer Cook so your case can be transferred.
Okay.
How will you get to, assume for a moment you're accepted into accountability court. They meet here in Atlanta over on the west side. How will you get from Marietta to there? Do you have your own car?
No.
Okay.
I'll either drive or my friend can bring me.
Okay. So Ms. Allen will help you with that?
Yes, sir.
Okay. All right. Good. I will sign the final disposition in this case with Behavioral Health Treatment Court being the outcome. Ms. Feely, you'll need to let me know if Mr. Bashir is not accepted into BHTC. And if he's not, then we'll do an amended sentence, but we'll need to put our heads together and learn more about the type of treatment he's getting that he referenced. And I will also sign, when Ms. Tucson gets it to me, a revocation order in the 11 SC case that's premised on this plea, but also that closes out the active probation warrant in that case. It doesn't revoke any time, but it will modify the conditions of probation in the 11 SC case to add the requirement that Mr. Bashir complete BHTC. Ms. Willingham, should I also add no contact with the owner of the car?
Yes, Miss Pakula.
Okay, so another condition, Ms. Nelson, another special condition of probation in the 23 SC case would be no contact with, can we spell the name?
Hold on. Linda is the first name.
Linda, standard spelling.
Yes. Last name is Pakula.
Pakula, Linda Pakula. So no contact with Ms. Pakula. Anything else, Ms. Willingham?
Nothing from the state.
All right. Mr. Bashir, do you have any questions?
No, sir.
Ms. Feely, how are we going to follow up with accountability court?
So once the referral goes through, then will I get a notice?
I typically, Judge, when I submit them, I usually CC defense attorney on it. And in past experiences, when they've responded, they've usually left both of us on there.
Great.
So I think we should both get notification.
Good.
And I will put it on my calendar to kind of double back with them in a month, I guess, right after Christmas.
Well,
I'm going to try to check back with them sooner, but
yeah, we aren't overwhelmed with applications right now. So if you can get something out to them, they ought to be able to move on it and figure out how to meet with Mr. Bashir. It's a little easier because he's not in jail, so they can set up a time and he can meet with them. So hopefully we can make that happen. I guess, Ms. Philly, the reason why I want to make sure you're in the loop is if it doesn't work out, then we need that plan B. Otherwise, he'll be in violation of his probation and that will end less well.
And what I typically do, Ms. Feely, just so you're aware, also, there's a portion on the application that actually asks for the defendant's information. So I will fill out the top portion. I'll send that to you, and then we can get that submitted to them.
Great. Okay. I think that is it for this morning. We're going to reconvene. I know it said 1 o'clock. It's going to need to be 1:30. Just so we can build in lunch for everyone. So our calendar this afternoon, we will resume at 1:30 for a few more final pleas. We'll see what happens with them. I don't know, Ms. Willingham, if you had any of them, but if you had Mr. Newbill, he's gonna not be here after all.
I
That's
do
it.
have some, it's not Mr. Newbill.
Okay.
So.
All right, then we'll see you and Ms. Clark and Ms. Wood and Ms. Feely, and maybe some other lawyers, at 1:30.
Excuse me, Judge.
Yes, ma'am.
Actually, for the revocation order, you didn't specify how much time we were revoking on his case when I typed that up.
Sure, I wasn't planning on revoking any time because I wanted to keep the entire balance still out there, that 2 years plus. So it was a revocation with no time revoked, just modifying the condition of probation by adding that condition.
Okay, and then that will cancel out the warrant in Odyssey, right?
I hope it does. Yes, I would like it to.
Okay,
All right.
just want to make sure.
All right. Thanks, everyone.
See you this afternoon.
Okay. Cool. All right, I think we should be back in session, except I'm about to sneeze. Ms. Rivers, can you hear us?
Yes, I can.
Great. Happy afternoon to you. We've got a shorter final plea calendar with one plain arraignment tucked at the very end that we will march through. Our first position is Jarius Anderson. Is he in custody? Okay. Ms. Wood will bring him. Ms. Wood's not. Ms. Wood is, she's virtual. You guys all shift around. Okay.
This is a case that was resolved in a plea.
Oh, okay. Hold on. Let me get my notes. I did get that email at the start of the day where Ms. Nelson spelled all that out. Anderson, resolved with a plea. That's right. Okay, done. Great work, Ms. Wood and Ms. Clark. You're off to a good start. All right. How about Mr. Wright? Levin or Levon Wright?
Judge, I just talked to him over the break. Let me reach out and see. He's supposed to be appearing via Zoom.
And he would be appearing from where?
From,
Like, is he local or is he somewhere far away?
I think he's sort of local, but I'm pretty sure he's at work right now, but I'm gonna text him.
Okay. Ms. Marsh, is this how are you?
Good, Judge. How are you?
I'm well.
Good afternoon, Judge. This is not my case. This is 88 Willingham's. I just left her behind and Judge Eaton. So
Okay.
I'm prepared to stand in.
Okay. If he shows up.
Yes, Judge.
Got it. Okay. How about Mr. Newbill? Did Mr. Newbill show up? He didn't need to. Ms. Clark, is this your case?
Yes, Your Honor.
When I say he didn't need to, Mr. Rucker has a leave of absence of unknown duration. And I think his office was reaching out to Ms. Nelson. She reached out to me and I said, look, if Mr. Rucker can't be here, there's no point in Mr. Newbill being here. So we will reset this for another final plea.
Okay.
Mr. Wright, we just talked about. Mr. Everett?
He's in custody, Judge.
What'd you say, Ms. Wood?
He's in custody.
Oh, okay. So he's here in custody. All right. We'll handle his in just a minute. Is that also Ms. Willingham case?
That one is mine, Judge.
Actual Marsh case. All right. So he's here in custody. How about Antonio Johnson? Okay, he's here.
He's mine. I spoke with him about the state's offer and we are not accepting it as time to receive your final please.
Okay, we'll get him out here in just a minute. Ms. Wood, what are we doing with Mr. Everett?
Judge, I've spoken to Ms. Marsh. There's an open CP case and also a probation matter. This will not resolve today. I need to get my social worker involved, but I do expect this to resolve short of trial.
Okay. How about Jameer Kashmir? Right there. Hey, Mr. Kashmir. Ms. Clark, is this your case?
Yes, Your Honor.
All right. Ms. Wood, what are we doing today with Mr. Kashmir?
We are doing a final plea hearing, Judge.
Okay. And just out of curiosity, what happened?
Co-defendant Javon Woods is in judicial hold.
Well, you answered my question.
Okay.
That's what I was trying to figure out. Well, what about this Woods guy? Okay, so he is not available right now. Okay, Mr. Kashmir, we'll handle your case in just a sec. I'm just figuring out what we're doing. And then we've got Royal Parham. Is he here? Hey, how are you? I'm all right. So this, I had some notes as well.
Yeah. It looks like it's going to be my case, Judge. Ms. Cabrera-Demore.
Yes, that's what my note said, that you'd be taking this case. Excellent. Okay. Well, why don't we start? I'm going to add you to the spotlight right there. How are you doing?
I'm well. How are you, Judge?
I'm good. Do you have a good Thanksgiving?
I did.
Excellent. Well, we're going to start with this just since it's going to be plea and arraignment. That's quick and you're here. Let's do, is Mr. Parham waiving arraignment? Do you want him formally arraigned or what's the best way to do it? Come on up, Mr. Parham. He's going to come up to the podium so you can see him. And Ms. Clark, this is your case?
Yes, Your Honor, it is.
All right, great. So you were here, Mr. Parham, last time, or you may have been on virtually, in October, about a month ago. And the question was representation. Mr. Olive rolled off the case, and it looks like Ms. Cabrera de Mora will be handling your case. We just need to handle the arraignment piece, and then I want to make sure you've got a good way to contact Ms. Cabrera de Mora and vice versa, because you'll be working together going forward. So Ms. Cabrera de Mora, is Mr. Parham going to waive arraignment and you'll enter the plea of not guilty and we'll move forward, or does he want to be formally arraigned?
No, Judge. We'll definitely waive formal arraignment, enter a plea of not guilty. And I'd ask for 10 days to file any motions. I do have discovery now. The state made sure to get that to me. And the state also was able to share with me their thoughts on an offer, or sent me their offer. So I can share that with him. I'll just need a contact number for him and I can give him a call later today, probably after about 4.
Okay. That sounds like a plan. You don't need to worry about the 10 days because once we see your waiver of arraignment, then we'll issue a scheduling order and that'll have a deadline for the state to get you discovery. Sounds like they've already met that deadline. But more importantly, it'll give you a deadline a little ways out to file any motions if you are going to file them. So let me see here. This bounced to us from non-complex. Thank you. Because, okay, got it. Mr. Parham, we gotta make sure we've got a good address for you. I've got Valleydale Drive in Riverdale. Is that good? Okay. What's the best way for Ms. Cabrera de Mora to reach you?
Phone
Okay, what's that phone number?
470-875-2341.
Did you get that?
I did. And what I'll do is I'm in court in Cobb now, but I'm going to text him in the next like 5 minutes and he'll have my phone number.
Okay, so Ms. Cabrera de Mora will send you her phone number through that text. You'll be connected with her. She's going to want to meet with you sometime soon, show you the discovery, talk about whatever the state's offer is, and the two of you will figure out a plan to move forward. You'll get something in the mail to that Valleydale address every time you need to come to court. But your best way to learn about what's going on is to stay in touch with Ms. Cabrera de Mora because she'll get notices as well. She'll get them more directly. They'll be emailed to her. You'll get them through the postal service. Any questions about anything?
No question.
Okay. Let me check one more thing and then I think you can be on your way. So, man, this is an old case. This should be resolvable. Your bond was set 3 years and 1 month ago. I need to make sure you're not wearing an ankle monitor or anything. Good. You were supposed to stay away from Boulevard. You've been staying away from Boulevard? Good. I was going to say they're not near each other. So you stay south, stay away from Boulevard. And I will see you sometime soon when you and Ms. Cabrera de Mora figured out next steps. Okay.
Okay.
All right. Anything else, Ms. Cabrera de Mora?
No, that's it, Judge. I'll make sure I'll file the waiver of arraignment this evening.
Sounds good. Ms. Clark, anything else?
No, Your Honor.
All right. Thank you. You're free to go.
All right. Thank you. All right.
You too.
Thank you, Judge. You guys have a good one.
All right. Take care.
All right.
Investigator Castro. I need a couple minutes to take care of some of this other stuff, but I will get to you, okay? You bet. Okay. So let's handle Mr. Everett. Can we bring Mr. Everett out, please? Hey, Mr. Everett, how are you?
All right.
Great. Let me get Ms. Wood on the screen, your lawyer, so you are able to see her. There she is. This is position 5 on our final plea calendar. State versus, is it Terrell or Terrell? Terrell Everett. Mr. Everett, Ms. Wood told me that there may still be a way to work out all your stuff, but you've got an uncharged case and a couple other things going on, and she wanted a little more time. I need to get the state's offer on the record, what they're recommending today. Then I'm gonna ask you a few questions and we'll figure out what we're gonna do, okay? Ms. Marsh, if Mr. Everett wanted to resolve his case, the only one he could plead to right now, the indicted case, what is it that the state is recommending?
Your Honor, the state's recommendation on this case is 2 years to serve.
All right. So, Mr. Everett, if you entered a plea today, the state would recommend 2 years to serve. That doesn't mean that Ms. Wood would have to recommend 2 years, but I'd have the prosecutor, who knows a fair amount about you and your case, saying we think the right sentence is 2 years to serve. Ms. Wood would be free to argue for something different. If I sentenced you to more than what Ms. Wood, your lawyer, asked for, you could withdraw your plea. So I'm going to make numbers up. Ms. Marsh says, Judge, 2 years. Ms. Wood might say only 1 year, credit for time served. And if I said, nah, I think Ms. Marsh is correct, I'm going to sentence you to 2 years, you could withdraw your plea, say, I was willing to take what my lawyer was asking for, but not this other number. Okay, no problem. You'd be right where you are. You could still go to trial if that's what you wanted to do, and there'd be no adverse consequences for you. After today, because today is your final plea day, after today, you can always enter a plea. The only thing that changes is that you won't be able to say no thank you if you don't like the sentence that I give you. It's like if you go to trial, if you're found guilty, you don't get to say no thank you to a sentence. If the jury says guilty, then I have to give you a sentence. The state's offer may stay the same. It may always be 2 years to serve. It may get better. They may learn more about the case and say, oh, okay, how about 18 months? It may get worse. They may say, now we have to talk with the victim and that's difficult for her. And now it's 3 years to serve. You don't get to keep this offer open. You understand all that? Yes?
Yeah.
Okay. Ms. Wood, it's my understanding that you and Mr. Everett are not interested in pursuing the 2 years to serve right now, and that you're looking for a global resolution that would address some of these other things. Is that correct?
That's correct, Judge.
Okay. Let me check one thing.
And Judge, when you have a moment, I would just like to put a few things on the record about the other matters.
Sure.
Because I will be needing some time as well.
Okay. Mr. Everett, your case is on my January trial calendar. So I will see you at the latest on January 10th. That's when we call that calendar.
Okay.
And it may be that you all have worked things out by then. If you haven't, then maybe we need to get you into trial. But we're not forgetting about you just because it doesn't resolve today.
Right.
Ms. Marsh, what did you want to add?
Yes, Judge, that was actually what I was going to talk to you about. So Mr. Everett currently has two pending matters. He has a probation violation before Judge Lethbridge. That case number is 14SC 128229. That did come before Judge Lethbridge's calendar on the 20th, but it was continued because the defense attorney had a conflict. I am also assigned to Judge Lethbridge, so I'm trying to work that out. But he also has one unindicted case still pending. That is 23 CP 218569. That lead charge is aggravated battery. Then there's also an additional case that was dismissed at prelims because the officer didn't show. I'm going to look into that to see if we would like to indict that. And that case number is 23 CP 220639. Judge, all of these cases would not have been mine. They're not sexual-related offenses. However, I'm willing to take lead on getting them indicted and everything. I just need time to do that. I don't know if I'll be able to do that by January, Judge.
Okay, well, we're going to keep it on the trial calendar. Mr. Everett's sitting in jail. I understand he's got these other cases. And we will see what you're able to get done and what you're not. And I suspect that if you are making good progress on a global resolution, then there won't be opposition from Ms. Wood or Mr. Everett to say, well, let's not try the indicted case on the January calendar. As you know, there'll be plenty of other things we can work through. But I do want to keep a little pressure on so that, I mean, you may look at, I'm looking at the thing that, the matter that was dismissed because the officer didn't show up, and it's obstruction of officer. So not an unserious allegation. If he was threatening an officer, he needs to be held responsible for that. But it's not battery on an officer or assault on an officer. So that one maybe falls a level below the aggravated battery that's unindicted in terms of the seriousness of the offense. But you do have a few moving parts. And I want to give you a chance to look at all those. I'm sure Ms. Wood will help as well. Somehow Ms. Wood is listed as the lead attorney in the one that got dismissed. So I don't know if she was plugging in to help out with that or what, but I hear you on that. Ms. Wood, anything you want to add on behalf of Mr. Everett?
No, Your Honor, thank you.
You've got the discovery you need for the indicted case?
Yes, Judge.
Okay. All right. What's the range, Ms. Marsh, for the charge in the indicted case?
1 to 5.
1 to 5? Okay. All right. Mr. Everett, do you have any questions? Okay. Well, Ms. Wood will be out to see you soon. I will see you in January. Even if we're not sorting everything out, I want to talk to you again so you know we're not forgetting about your cases. We'll get an update from Ms. Marsh as to the work she's been doing to see if she can get your unindicted cases resolved as well. Ms. Marsh, do you have any sense, since you are an attorney in Judge Leffridge's courtroom, the probation violation, will that be put on hold to see if it can all be wrapped together, or Judge Leffridge wants to go forward with the revocation?
I'm not sure, Judge. This will be my first probation violation before her.
Mhm.
I do know that she is ready to resolve it, as it was on the calendar twice prior.
Okay.
So I believe on the next date, she's going to be ready to go forward.
Okay. Well, a couple options. One, you can let her know that we're happy to roll it into what we do. Two, if when you're talking with Mr. Everett's attorney on that side, if it's going to be a messy revocation for Mr. Everett, sometimes the attorneys say, well, what if we stipulate and we wrap all this other stuff into it? I would have no objection if the way you resolve this sexual battery is through a plea over there in front of Judge Leffridge in conjunction with the revocation. That we can have it flow, whatever is most efficient for you and Mr. Everett and his attorneys.
Okay, Judge.
All right. All right, Mr. Everett, that is it for today. We'll keep your case on the trial calendar.
And Your Honor, that's all I have, ma'am. Excuse.
Yes, ma'am.
Thank you.
Let's bring Mr. Johnson out, please. And then Mr. Wright has appeared on the call. Okay, we'll make a record now on position 6. It's 23 SC 188-706, State versus Antonio Johnson. Hello, Mr. Johnson.
Hi.
How are you?
I'm fine.
Good. Mr. Johnson, you're represented by Ms. Feely, who is standing right next to you. And Ms. Clark is the prosecutor handling your case. She's standing behind you. We're going to talk a little bit about where we are in the course of resolving your case. This is your final plea date, which doesn't mean it's the last day in which you can plead, but it is the last day in which you could enter a plea and be able to withdraw that plea if the sentence I gave you was more or worse than what Ms. Feely asked for. your situation is a little complicated because you're charged with armed robbery. And I don't know what the state's offering. They're going to tell me in just a minute, but that carries with it a minimum of 10 years to serve. So Ms. Feely might think that your case is something that should resolve at 4 years or 5 years or 1 year. But she can't ask for that because the floor for armed robbery is 10 years. So that makes it a little more complicated to resolve sometimes, but it also depends on how strong the state's case is. Ms. Feely, have you reviewed the record and developed a comfort level with whether you've got what you think all the discovery is?
I believe so.
Okay, as far as you can tell, nothing missing.
Right.
Great. Ms. Clark, what is the state's offer if Mr. Johnson wanted to resolve the case with a plea today?
20 years served 10, balance probated.
All right, and that's the statutory mandatory minimum. And you'd be running the armed robberies and the home invasion concurrently?
Yes, Your Honor.
Okay. All right. So, Mr. Johnson, if you were to enter a plea today, the state would be recommending the minimum in terms of time to serve, 10 years. You'd get credit for the time you've already been in, followed by 10 years of probation. So 20 served 10. You understand the state's recommendation?
Yes, sir.
Okay. Is that something you want to pursue today, or would you rather have me move your case to the next available trial calendar?
Yes, tracking.
Trial calendar. Okay. Well, that one is January 10th. So we'll bring you back here January 10th, figure out the order in which we're going to try our cases. You've been in jail for a while, so this is one I try to move towards the top of the list, and you're not going anywhere until we resolve this case, however we resolve it, whether it's a plea or the jury hears the evidence and decides guilty, not guilty. Ms. Feely, anything else we need to get on the record in Mr. Johnson's case?
No.
Okay. Mr. Johnson, I just need to make sure that you understand before you go today that this offer from the state is good through today only. So it may be that you decide in a month, I don't really want to go to trial and have the jury hear from these victims or whatever. So I want that 20 served 10. Ms. Feely may not be able to get you that offer anymore. It may be, I'm making the numbers up, 20 served 12 or 20 served 15 next time Ms. Feely asks. It may get better. They may dismiss counts, but you don't have a way to keep this offer open. You understand that?
Yes, sir.
Okay, good. Any questions about anything?
I guess my
You can certainly talk. She can come back and talk to you.
Okay.
Any questions for me about what's going on with the case?
about my motions, had they been denied?
So motions that you filed?
Yes, I think I did.
So I'm gonna look, but if you have a lawyer, then generally a motion that you file, we call it pro se, if you will file something on your own, I don't rule on those because it's your lawyer who does the motion filing. So you can file whatever you want, but generally, I don't work through those. It would be something, but I want to see if there's anything in there. I don't see any motions in the docket. There was a bond motion that was filed in May of 2021, but then you got a bond set in July of 2023, a little bit late, but there was another motion filed in June. And then here we are. So there aren't motions in the docket. That would be a good thing to talk to Ms. Feely about. And you and she can work through that. Any other questions for me?
No, sir.
Okay. All right. Thank you. Thank you, Ms. Feely. Do you have anything else, or you can go talk to him?
I don't, but I'm happy to stick around with Ms. Wood being virtual. But
Okay, great. So if you can keep Mr. Johnson up, please. All right, Mr. Cashmere, come on up, please. You just stand right at the podium. All right, let's get on the record with your case. Position 7 is 23 SC 188710. You're represented by Ms. Wood, who you can see on the screen there. She's appearing virtually. Ms. Clark has the case for the state. Ms. Wood, do you have all the discovery you're aware of in the case?
Yes, Judge. I received discovery last week, so I would ask that the final plea rights be preserved for moving forward.
Okay. Ms. Clark, any reason for the late delivery of discovery?
Your Honor, I'm not sure as to why it wasn't served before. I just noticed that it wasn't served.
So you jumped on it once you saw it. It just, it hadn't happened before you got in the mix.
Right.
Okay. All right. Ms. Wood, not a problem. We'll do that. In your brief review of the discovery, are you thinking there are motions that we'll need to work through, or it's more so you want an opportunity to pursue leads you see in there, have time to talk about it with Mr. Cashmere, et cetera?
I do need to review all of the videos to make sure there's not a Jackson Ditto motion, Judge.
Okay, got it. Anything else on behalf of Mr. Cashmere?
No, Your Honor.
Okay. What we're going to do then, Mr. Cashmere, is rather than go through this whole thing about final plea and what's the state's offer, because discovery only recently got delivered to your lawyer, I'm going to keep your case on the trial calendar in mid-January, and that's when I'll see you next. So we don't have to slow anything down, but I'll keep your final plea rights open. So when you come back in January, if you decide you want to try entering a plea, but maybe the two sides don't agree, then your lawyer can recommend what she does. And if I disagree with that, you'll be able to withdraw your plea. Okay? Any questions about anything?
No question.
I'm just looking up your case to make sure we've still got good info on you. What street you live on?
Lakeview Road.
All right. So, Ms. Wood, I'll need you to get a new address in the system for Mr. Cashmere because I've got him on Lennox Road. Do you live on Lennox Road?
Yes.
How long ago was that?
About a year and a half.
Okay. So we'll need to update Mr. Cashmere's. How'd you know to be here today?
I looked at it a long time ago. I already knew.
Okay. It's not something that came in the mail. No, it's not. All right. So we got to get you your new address. You've got good electronic contact info for Mr. Cashmere, Ms. Wood?
Yes, Judge.
Okay. Well, if you could get his correct address and get a change of address filed, I'd appreciate that.
Will do.
Okay. That's it. Ms. Clark, anything else in this case?
No, Your Honor.
Okay. Mr. Cashmere, make sure you get that address to Ms. Wood. She'll get it into the system, and I will see you in January. All right. Thank you. So all that is left is Mr. Wright, who is on the call now. How you doing, Mr. Wright?
Hello.
How are you?
I'm okay.
Tell me where you are. Are you in the Atlanta area or where are you?
I'm in Decatur.
Okay. All right. We're going to need you to come to court at some point.
Yes.
I thought you would be here today. It's good that I can see you, but we're going to need you to actually come on into court.
I was on my way, but I've been under a lot of stress. So I apologize about that.
Okay. Well, let's see if we can agree on a time. Maybe next week you could come on into court, or tell me what. I don't want you to be under stress. Excuse me, but I do need you to come on by. When When could we do that? Are you working?
No, I just lost my job, so because of this case. So I need to I definitely need to fix it.
Are these cases connected, Ms. Wood,
I
in
actually
terms of facts or people, or Ms. Willingham? They're not?
Judge, they're two different victims.
Okay, got it. All right. I'm wondering if we just want to defer the final plea to next week, or if we want to do part of it. And the cases will still be on that January trial calendar. Do you have a preference, Ms. Wood? What if we did this? Mr. Wright, is there any reason you could not be here? We're calling a trial calendar, not yours, don't worry. This Friday, Friday afternoon. Any reason you could not be here Friday afternoon?
I could be there Friday afternoon.
Okay. Then what I'd like you to do is be here in courtroom 8D as in Delta at 1 p.m. on this Friday. That's December 1. Ms. Wood, do you have good contact information for Mr. Wright?
I do now, Judge, so I will make sure he remembers.
Okay. You got it?
Yeah,
December 1 at 1. That's this Friday. All right, you're on mute, but as long as you gave me the thumbs up, that's good.
1D?
What, courtroom 8 Delta, 8 Delta, 8D.
Okay.
All right, Ms. Wood, anything else?
No, Your Honor, thank you.
All right, thank you, guys. I think that's it for the final plea calendar. Anyone I missed or anyone we need to talk about more? No? Okay. Well, thank you, Ms. Jackson, Ms. Tucson, Ms. Rivers, everyone else. I will see some of you, I guess, later this week. You're welcome to sign off. I got to leave this Zoom up for a civil thing we've got a little bit later.
Thank you. Have a good night.
There's the podium. Let me mute that.
Your Honor, you're on mute, Your Honor.
That's right. All right, let's try that again. Good afternoon. Wondering who is on for the matter of the parks at Cedar Grove versus Geneva Wells.
Yes, Your Honor. Burke Saul's here for the parks at Cedar Grove.
Hello, Mr. Sauls. How are you?
Doing well, Your Honor. It's been a while.
It has. I think we've got Ms. Wells. There's someone with that name on.
Yes, I'm here.
All right.
Your Honor, we also have Pam Cumberlander, who's the association manager, who's on here with us.
Okay.
Hello,
Hello.
Pam Cumberlander.
There she is. Great. All right. So what we are working through here, there's Ms. Wells. All right, let's add her. We've got everyone. We are working through an effort on the part of Parks at Cedar Grove to revive a judgment. Mr. Sauls, I'm going to let you take the lead, and then I will, of course, hear from Ms. Wells at the appropriate time. Why don't you get us started, Mr. Sauls?
Yes, Your Honor. Your Honor, I would call Ms. Cumberlander as a witness.
Okay.
Do you want argument and issue, or would you prefer to take testimony now as well?
So what I'd like you to do is start by just giving me the background. So this is a case from 2014.
Okay.
So why don't you tell me what the judgment was and why we are now in 2023 working through a judgment that was handed down back then.
Yes, Your Honor. Your Honor, the judgment was handed down on 11/7 of 2014. The judgment amount was $7,182.34. The association received money in December of 2015 in the amount of $7 from a payment from a bankruptcy case that Ms. Wells was involved in at that time. The association then attempted garnishment actions in 2018 and received the payments that are reflected on Exhibit C in October of 2018 and of May of 2019. Your Honor, as far as why the judgment was allowed to go dormant, I can't speak to. We were not representing the association at that point. However, by operation of law, it did go dormant in November of 2021. And we have brought the action within the 3 years permitted by statute to have this revived, as the judgment has not been paid off. There have been some additional payments that Ms. Wells has made at various times, but those were on a 2023 judgment that was obtained against her in, I believe it was March of 2023, in the amount of $7,388.07. She has made payments on that sufficient where it's gotten it down to $6,594.10. We believe that part of her opposition to this may be due to some confusion as to the fact that those payments were not applied to what was a dormant judgment at that time.
Okay. So what is your, and maybe this will be the testimony that you'll be getting from Ms. Cumberlander. What do you understand to be the amount owed now?
$7,704.95. Of that, $2,900 $52 and give me 1 second, Your Honor, and I'm sorry, $2,032.07 is from the principal balance of the original judgment. $748.69 is the interest that was included in the original judgment. And then post-judgment interest in the amount of $4,024.19.
Okay, so most of it's post-judgment interest. This figure of 7704 reflects payments that Ms. Wells has made, the things you've referred to, but because the total balance wasn't paid off, we've had post-judgment interest accruing over these many years.
Correct, Your Honor.
Okay.
And that's what gets us to the amount that we're seeking for the revived judgment.
Okay. All right. Well, why don't you put Ms. Cumberlander under oath, get the evidence that you want, and we'll see if Ms. Wells has any questions for her, and then we can get argument from both sides.
Okay, Ms. Cumberlander, if you would, please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, could you please state your name for the record? Oh, you can put your hand down.
Okay, Pamela Cumberlander.
And what is your position as it relates to the parks at Cedar Grove?
I am the Community Association Manager for the Parks at Cedar Grove Community Association.
Okay, and as the Community Association Manager for the Parks at Cedar Grove, are you familiar with the books and records of the association?
I am.
And when did you take over as the manager for the Parks at Cedar Grove?
March of 2019.
Okay. And are you familiar with the historical books and records prior to taking over?
I am, for the most part.
Okay. Was that part of what was necessary when you took over, was to familiarize yourself with that?
Absolutely.
Okay. And have you seen Exhibit C that was attached, the spreadsheet that was attached to the petition for scarifacius?
I have.
And does that accurately reflect, based off of your familiarity with the books and records of the association, the total payments that have been received by the association towards this judgment?
Yes.
And those total $3,448.94. Is that correct?
For this judgment, the total, including the interest, or?
No, the total payments that have been made on the judgment.
Yes.
Okay. Nothing further, Your Honor.
All right. Ms. Wells, do you have any questions for Ms. Cumberlander?
Yes, I do. I really don't have any questions. I want to state what's been going on, because they've garnished my wages several times, and they just garnished my wages not too long, about 3 months ago, and got money. And plus I've been making payments that was going into the home association online. I've been doing that I had made a payment with Lisa First. She's the attorney that I thought that was going to be on today. And I've been making arrangements I made arrangements with her. Back in 2022, I went to court, and there was whoever was the attorney before them. I had made arrangements to pay it off at $4,000, and he agreed. I told him that that was in November of last year. I told him that I won't be back in town until January. When I came back in January, that's when I got another one of these judgments that had had 2014 on it. And I decided to go ahead and call her. So I went ahead and called her, and I had a conversation with her, and it was so overwhelming because she started telling me that I owed $20,000. And I'm just like, well, that's not what this judgment says. And the judgment says $7,000. And then she goes, well, ma'am, this is, she kept on, she was really throwing out all these numbers. She said I owed, she first started off at 12, went up to 15, 17, and then she went up to 20. And then I was just like, can I make some type of arrangements? Can I And I asked her again, why is this saying 7,000 and why is this so old? I thought you guys just garnished my wages. You guys garnished my wages before. I thought this was paid. I had no idea that it was not all paid until November of last year when I had got excuse the noise in the background too. But because of the judgment that I had got, not judgment, but because of the court date that I got last year, that's when I found out that there was still a small balance due. And I don't think it was the original balance. It was like astronomical, where I paid it down to like $3,000, and then when I got this judgment, it went back up to $7,000. So it is just, I'm getting so overwhelmed with these people. I called in and I asked if I could get some type of somebody to help me with them, because it seems like when I try to make arrangements, they said when I tried to even make it even 2 months ago, Lisa first was saying no, she cannot. She cannot take my what is it called? What's it called? Like a payoff payment. She would not do that with me. So that's when I said, okay, well then I'll just start making payments, and that's what I've been doing. And then she also garnished my wages as well.
Okay, and when you say she, who is the she?
I thought it was the attorney. That I don't know. It says the parts at Cedar Grove, but I've been talking to Lisa, whoever Lisa first is. She told me that she was the attorney, so that's who I had been talking back and forth to.
Okay. Well, let me ask Mr. Sauls a couple questions. Mr. Sauls, would it be your firm that Ms. Wells would have been dealing with if it was this year, or a different firm? You mentioned that your firm is newer to this case. I don't know the timeline.
That would have been our firm. Lisa First is one of the other attorneys in the office here, Your Honor. She was unable to appear today, and so I'm here on her behalf.
Great.
And again, there has been discussion about paying off balances. There have been garnishments that have taken place with the, I believe with our firm and with the prior firm, as far as the judgment that was the second judgment that was entered. But, you know, again, we've got this judgment's never been paid off.
Okay. Ms. Wells referred to a $20,000 figure. That wasn't anything in your vocabulary. Any sense of where a number that large would be coming from, or is Ms. Wells misremembering a conversation she would have had, not with you, but I guess it would be with a colleague?
Your Honor, the balance as of 8/11/2023, which I believe is when she may have spoken with Ms. First or around that time. Excuse me, Your Honor. The judgment for the 2014 judgment was $7,704.95. The balance outstanding on the 2023 judgment was $6,594.10. And then, excuse me, litigation, attorney's fees from the collection revival of the judgment that had accrued post-judgment came out to just a little over $3,000. So we were looking at about a $17,300 figure in total at that point.
What's the 2023 judgment? That's a completely different case?
That's correct, Your Honor. Ms. Wells.
Okay, can I
No, Ms. Wells, Ms. Wells, do not interrupt. I promise I'll hear from you again. I listened for a long time, and now I'm getting a little information from Mr. Sauls.
In 2023, the association obtained a judgment for assessments from July of 2018 through February of 2023.
Okay, so Ms. Wells unfortunately is having to work through multiple judgments. This is not a one-time situation, but it's been recurring. And that's why if you add them together, you get a number that's much larger than where you started, which was the 7704. And you broke that down, and I understand where that came from. And really, this effort to revive a dormant judgment is focused just on, as you've said at the outset, the 2014 judgment, which was, originally $7,000. Ms. Wells has made many payments, as we all acknowledge. That got down the principal of that judgment to to just under 3,000. But of course, interest continues to accrue. That's the bugbear of having old judgments that you haven't paid off, which has grown that amount owed on the 2014 judgment to the 7704 that you're talking about.
That's correct, Your Honor.
Okay. One other question, and then I'll hear from Ms. Wells a bit more. She mentioned that her wages had again very recently been garnished. I don't know exactly how garnishing works. That doesn't happen in front of me. But is that an on again, off again thing? Is that something your firm would have been involved with? And was that even related to the 2014 judgment, or because Ms. Wells has managed to be sued not once but twice for failure to pay these fees, she might be getting garnished because of the new judgment and not the old one?
The garnishment back in August would be from the 2023 judgment, not from this judgment.
Is your firm involved with the 2023 judgment as well?
Yes, Your Honor, we took over full representation from the prior law firm on this, so we're handling both judgments.
Okay, so if Ms. Wells is talking to you or Ms. First, she's talking to the right people to manage the collection process overall. She doesn't have to find two different law firms to handle the two different judgments.
That's correct, Your Honor.
Got it. Okay, that's very helpful. Ms. Wells, I'm happy to hear from you some more. It does sound like for many years, you have been wrestling with staying current with your association fees. I don't know if it's been an unwillingness to pay or an inability to pay, but we got 2 lawsuits now that you're working through.
Okay, so that's where I'm confused about, if you don't mind, explaining that. Because I do see that there is a lawsuit here from 2014 that I'm looking with, and it has the same amount, and it looks like it's the same judgment. It looks like everything is the exact same, and so I'm confused with the two. So can you kind of explain that to me for just a second, if you don't
Sure.
mind?
So you actually have 3 lawsuits, but only 2 sets of debt. Your 2014 judgment went dormant, meaning it was partially collected but not fully collected. And then there's a time limit to judgment so that people don't have to live with the judgment hanging over their head forever and ever. And if a creditor fails to act upon that judgment after enough time passes, you can say it's not my problem anymore. They didn't come to collect, and so I'm free of that obligation. There's an in-between window when it becomes dormant, but the creditor can say, wait a minute, here's why, and we want to, and this is what we're doing today, we want to revive that judgment. In other words, wake it up. It's not dormant anymore. It's awake, and we are going to actively pursue it. That requires a second lawsuit. And so technically the lawsuit we're here today is a 2023 lawsuit, and that is an action by the homeowners or the community association to revive the judgment from 2014. So it's exactly the same numbers. They are reviving that judgment. Now, it's exactly the same numbers, meaning it was originally $7,182. But as Mr. Sauls has helped me understand through Ms. Cumberlander's testimony, you've paid off a bunch of it, but interest has been accruing as well. And so it's a slightly different number. But if you're looking at the paperwork associated with a lawsuit that ends in 135, it's going to look a whole lot like the paperwork from 2014 because it's the same thing. It just went dormant, and they are reviving it, which they're entitled to do. If they had waited too much longer, then they could not revive it. But that door didn't slam closed yet. And so Mr. Sauls has done all the proper steps. And by having Ms. Cumberlander testify as to the paperwork or the accounting background, they've checked the boxes they need to revive that judgment. So it's 3 lawsuits, but really only 2 debts that you have. One was from 2014, and there's a whole separate one. It's a little confusing because the dollar amount is about the same, but it sounds like it's more like $6,000. That's the other 2023 lawsuit, but it's what Mr. Sauls referred to as the 2023 judgment. You have only 2 judgments, 2014 and 2023. but 3 lawsuits. One of the 2023 lawsuits is this thing to revive the 2014 judgment. Does that make sense?
I'm sure. Yeah, I think I got it. I think I understand what you're saying. Yes,
Okay.
but yeah.
Okay,
Right.
so let me tell you what my role is not in this. I am not the mediator or the one who facilitates settlement negotiations. I encourage you to speak with Mr. Sauls about steps you can take to make this go away by coming up with a payment plan, or hey, how about this? I give you X dollars right now and you go away forever. And there is some dollar amount that would be worth the community association's while to get money now rather than a little bit over time. That's a conversation you should have with Mr. Sauls or Ms. First. She hasn't gone away. She's just not available today. I don't get in the middle of those things to say, well, that doesn't seem so fair, Mr. Sauls, or come on, Ms. Wells, you accrued these debts, you need to pay them. That's not my job. I was asked to preside over this piece of litigation, which is this very narrow question of, has the community association done what it needs to revive, to wake up the dormant judgment? And they have. And the math is what the math is. The bulk of what you still owe from 2014 is now interest. It's not much principal, it's mostly interest. And sadly for you, that number only grows like credit card debt as long as it remains unpaid. So you're going to have the conversations you have with Mr. Sauls or Ms. First, and hopefully they're going to be reasonable about what they can expect from you. If you were a bazillionaire, you'd have paid this off long ago. And hopefully they recognize that you're not sitting atop a big pile of cash. Hopefully you recognize they are merely collecting a debt that is lawfully owed. And there's not a separate set of community assessments that apply to you versus anyone else who lives in that community. Mr. Sauls, is there anything else you think we need to cover from your client's perspective?
No, Your Honor, I believe we've laid everything out.
Okay. Ms. Wells, do you have anything else you want me to know or questions for me?
Yes, I absolutely agree with you. I do. Like I said, I wanted to make the settlement way back last year when I was dealing with the other people. And I still want to do that. But it just seems like I feel like when I give an amount, and I actually gave Miss First an amount, and she didn't seem to want to accept that. So that's why she pursued this. And my thing is, you're right, I'm not a billionaire and I don't have a lot of money. And I have a disability as well. And I want this debt paid off. Just like I told Miss First, I want this debt paid off. I want to be done with it. It has given me so much stress and I just want it to be over. And I, not saying it's you guys' fault. I know what I've done. But it's just me doing this. So like I said, if you guys can just be, just help me a little bit, please. I'll pay you. I can't pay the $7. I'd rather make a reasonable amount. Sorry for this, but I just want to make a reasonable amount just to let it go away, please. That's all I'm asking, to be fair.
And that's a very reasonable.
My wages, and you guys put me in another predicament, and so it's just hard, and that's it. I don't know.
Okay. Well, Ms. Wells, you're speaking from the heart, and I don't envy Mr. Sauls's role because he and his firm, they're going after folks who owe money. And I don't get the sense at all that you are someone who racks up these debts because you're gambling at casinos and driving fancy cars and then claiming, oh, I don't have any money to pay. That's not the situation at all. But it is complicated because, as you said, you recognize that these are debts that need to be paid. I encourage you to keep having conversations with this firm, and hopefully you guys can find a middle ground that is something that allows you and your family to maintain your livelihoods and also begins to make a meaningful impact on these obligations that you have with the community association. Mr. Sauls, have you presented to Ms. Niles a proposed order, or is that something you were waiting to do until we had today's proceeding?
I believe there was one that was submitted with the motion, but if she needs me to, I'm more than happy to send it, to resend it.
Okay, if you sent it, we've got it. If we can't find it, we'll reach out.
Okay.
And Mr. Sauls, I want to be as clear as I can with Ms. Wells. Should she be working with you or Ms. First? I don't want her to get stuck in a sort of, well, Mr. Sauls said this, but Ms. First said that. Is there a point person for her case?
Ms. First would be the main person she would want to contact with that, but you know, if for any reason she's in a situation where, you know, she's got a call up about like, oh, I got to get a payment in, you know, a little bit later, whatever, feel free to reach out to me if you can't reach Ms. First for some reason.
So Ms. First should be the primary contact, but if she's hard to reach, it's okay to reach out to you.
Yes, Your Honor.
And that would suffice. If Ms. Wells is just letting you know something's coming, it's going to be a little late, she shouldn't panic if she cannot reach Ms. First, because reaching you would be enough.
We make notes in the same system, Your Honor.
Excellent. Okay. All right. Well, Ms. Wells, I wish you the best on sorting this one out. I am hopeful that this firm will work with you. It doesn't benefit them not to work with you, because if you don't have it, you don't have it. And that's the reality. So hopefully there's a middle ground. And Ms. Cumberlander, thank you for your time in helping out with this. Okay.
Thank you.
All right.
Thank you, Your Honor.
Thanks, everyone.
All right. May we be excused?
Yes.
Thanks.
So what, do I,
Ms. Wells?
yeah, so do I call him? I mean, what do I do now?
Yeah, you want to reach out to him. I'm not giving you any legal advice, but I'm going to enter an order that revives this judgment, and then you'll want to reach out to him or Ms. First. You heard what he said. Ms. First is the primary contact, and say, all right, it looks like we've got a new landscape. What is it we can do here that doesn't involve you garnishing my wages? Because that's real awkward. Okay?
Thank you.
All right, good luck. Is the parentage thing on this Zoom?